maybe there could have been more questions asked that would have helped to mitigate against the creation of the real estate bubble that happened, and we know where that ended. So I think that the idea of striking this title is not a good one. I think it's important for accountability and for transparency with the Federal Reserve. And if he'd like a minute, I'd yield the balance of my time to the gentleman from Kentucky.
Thank you. I appreciate my friend and his remarks. In the remaining minute that we have, let me just kind of boil this down. The problem we have with the Fed today, the modern Fed, is that at the beginning of 2015, the FOMC and the chair projected that there would be 3 to 4 modest interest rate increases. And there was only one at the end of 2015. And then again in 2016, there was a prediction that there would be 3 or 4 modest rate hikes. And again, the Fed only delivered 1 quarter-point increase at the end of 16. The problem is they're not sending certain signals into the private economy, and therefore they're obscuring the price signals. And that policy uncertainty is leaving households and investors and individuals in the private economy and businesses scratching their heads about how to plan. And that undermines the capacity of the economy to perform at its maximum levels. And so, I'll just end with a quote from Milton Friedman, who I think summed it up well in 1967 in his address to the American Economic Association. "We are in danger of assigning to monetary policy a larger role that it can perform, in danger of asking it to accomplish tasks it cannot achieve, and as a result, in danger of preventing it from making the contribution it is capable of making." And my time has expired.
Time of the gentleman has expired. As the chair has announced, House votes have been called. The committee will reconvene immediately after House votes. The committee stands in recess. The chair has an announcement in consultation with the ranking member. No committee recorded votes are anticipated this evening. At the moment, we expect votes to be rolled till tomorrow at approximately 11 a.m. Further notifications will be given on the precise timing of recorded votes tomorrow. Who seeks recognition? For what purpose does the gentleman from Illinois seek recognition?
I'd like to strike the last word.
The gentleman is recognized for 5 minutes.
I just want to make a brief comment. I was very happy to see my Republican colleagues' enthusiastic support for the judgment of regional Fed chairs. In fact, the Minneapolis Fed chair and sometimes Republican politician Neil Kashkari has engaged in a many months long study of the capital requirements of large banks that would be necessary to prevent future bailouts. And interestingly, he has concluded that the capital levels in the Choice Act are wholly inadequate to prevent future giant banking crises. So this is, I think, a very interesting input to this, and the fact that we're going ahead and voting on this without that very insightful, as many of you, those of you who were there during the crisis will recognize the name of Neil Kashkari, who stood in for Hank Paulson many times during the crisis when Hank was unavailable, but we needed his counsel. So he is knowledgeable on the nuts and bolts of banks bailouts, and the fact that he concluded the capital levels must be much higher to have any reasonable expectation that we will not have future bank bailouts, I think is very important missing input for this. Well, that was the one comment I wanted to make, and yield back on this amendment.
Gentleman yields back. For what purpose does the gentleman from Indiana seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Well, Mr. Chairman, thank you so much for the time. Sometimes in this debate, and frequently in these debates, we get overly focused on specific titles and specific statutes and very narrow. So I thought I'd bring a little historical context to what we're talking about here with regard to central banks. Though Sweden was the first country to pioneer the idea of a central bank, the central bank as we know it as an institution really started in 1694 with William III. And the reason that they started it in the Bank of England was a deep-seated concern over central power, over a monarch, a despot that could capriciously default, would not be able to set forth his exact reasons for policy. And I think that those people that started the Bank of England back in 1694 would be aghast today to see the tremendous power that the U.S. central bank has. And we talk a lot about interest rates that the bank sets, but we've got to go back and look at exactly what a central bank is doing to consumers and to individual families. Now, when we affect monetary policy and we talk about interest rates, what we're really doing is shifting along consumer preferences. As we raise interest rates, we're forcing or incentivizing consumers to spend today, to save today so they can spend more in the future and consume more in the future. And as we lower rates, we're incentivizing them to spend more today. This is trillions of dollars, literally trillions of dollars we are moving back and forth in time just with the strike of a pen by our central bank. And I think that we are owed a level of transparency. We are owed a descriptive reason and clear methodology by which the central bank is determining what it should set rates at. Because this isn't something inconsequential, not inconsequential to the economy, not inconsequential to families. And I think that level of transparency that we expect in other areas of government, we should also expect in this. And I think transparency isn't just about the outcome, as my friends and colleagues across the aisle talk about, in that we specify exactly the outcome in terms of the interest rate level, but transparency is really about a description of how we arrived at that outcome. What was the data that we looked at? What did that data tell us in a model? And what was that model's output? And how are our decisions made relative to the output of that model? And so I think going back and understanding that deep-seated fear of an institution having too much power and making capricious decisions is exactly the advent of the modern central bank. And now to think that our central banks what was created to be the antithesis of centralized power, have gotten so much power over individual American lives and over the American economy. And to say that we can't now reform that, we can't now better understand transparency in terms of policy, I think is a tremendous mistake. And I would also push back against my colleagues across the aisle who claim that the Federal Reserve is the most transparent central bank in the world. In fact, according to the International Journal of Central Banking, the Federal Reserve is the 7th most transparent bank in the world, falling behind the Bank of Israel, falling behind the Swedish Central Bank, falling behind the Central Bank of Czechoslovakia. And one of the things that pushes the Federal Reserve down the ranks to become a less and less transparent institution is, in fact, what we are talking about today, the lack of a descriptive answer for how they arrive at policy outcomes, the lack of a clear model that says this is what this model would predict, and the Federal Reserve can then choose yes or no and why they might differ from that model's outcome. And so again, we're not saying that the model has to prescribe exactly what the Federal Reserve is doing, but it at least prescribes a methodology by which the Federal Reserve is going to analyze data, think about data, and then arrive at its outcome, and then justify whether its outcome and decision is materially different than the model's output itself. And so to me, I look at the historical context, that fear of centralized power. I think about today how much power the Federal Reserve truly has in being able to push and pull an individual families and Americans' consumption over time. And I think that that great power comes great responsibility, the responsibility for clear transparency about how they arrive at these decisions, not just the decision itself, but how they arrive at these decisions. And it's for that reason that I oppose the amendment and am in favor of the Choice Act's demand for accountability and transparency in the arrival of outcomes and decisions by the Federal Reserve. And with that, I yield back, Mr. Chairman.
Gentleman yields back. Who seeks recognition? For what purposes does the gentlelady from Ohio seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman, as I've been sitting here listening to both sides of the aisle, there is something that I think I can agree on. And let me just state for the record that I agree with many of my colleagues who have said during this markup that this is a partisan bill. And it is also a missed opportunity to work together on a bipartisan basis to keep our economy moving forward. We've heard members talk about how they have passed successful legislation with colleagues on the other side. I've been able to do the same. Democrats and Republicans both agree that community banks and credit unions need some relief. Mr. Speaker, there are even Democrats who would agree that there are legitimate questions regarding whether implementation of the Volcker rule is having its intended effect. Last month, in his final speech as a Federal Reserve Governor, Daniel Tarullo stated that the rule was too complicated, regulated by many government agencies, and was not workable because it required regulators to look into the hearts and minds of traders. With that said, even he believes that there is a role for the Volcker rule, and so do I. When this committee really gets serious, Mr. Chairman, about bipartisan efforts to improve Dodd-Frank instead of repealing it, I stand ready to work on these important issues with any members who want to do that. Mr. Speaker, also, I would like to share that earlier, there was a comment that was made along the lines of, it's difficult to be a party that proposes ideas and policies while the other side continuously says no over and over again. Well, if it wasn't so serious, it would be funny. Let me remind people of what has happened over the last couple of years. Democrats proposed a health care plan that gave 24 million people access to affordable health care, while Republicans repeatedly said no over and over again. Republicans were the party of so much no's during President Obama's administration that they voted over 60 times to repeal the Affordable Care Act. Then, when there came time for them to be in a position to repeal and replace, they couldn't do it. I think the words were, I heard that they found out or remembered that it was complicated. Well, of course, you can't do something that we worked on for 7 years and then in a few weeks try to roll out a plan. Rolling out a plan that they had been negotiating in private back rooms to cobble together enough votes that they couldn't do to pass their own health care bill. So I would say to those and the rest of the colleagues on the other side, Democrats know exactly what it feels like to propose ideas and have opposing party continue to say no, no, and no over again. Also, let me say, as it relates to the FORM Act, the current Federal Reserve Chair, Janet Yellen, specifically cautioned Congress about advancing the FORM Act in a letter that was dated November 16, 2015. Mr. Chairman, I would like to enter this letter into the record.
Without objection.
In this letter, Chairman Yellen warns that the enactment of the FORM Act would severely impair the Fed's ability to carry out its dual mandate of maximum employment and stable prices. She goes on to say that the FORM Act would severely damage the United States economy if it were to become law. Now, Mr. Chairman, you cite 3 Nobel laureates who are in favor of the FORM Act, which I have no reason to doubt. However, in her letter to House leadership, Chair Yellen states there is no consensus among economists or policymakers about a simple policy rule that is best suited to cover a wide range of scenarios. She goes on to state, as an example, had the FORM Act been law throughout the financial crisis in 2008, millions of Americans would have suffered unnecessarily joblessness. So for those reasons, I ask my colleagues to join me in supporting this amendment. And last, Mr. Chairman, let me just say, frequently I have heard you state how wonderful it would be if we came up with ideas and if we worked together. Well, I don't think anyone will leave this hearing not knowing that we have come up with ideas. And I figure if we're too far to the left and too far to the right, I don't understand why we can't come to the middle and find some of these amendments that we can build on and take. I yield back.
Time of the gentlelady has expired. For what purpose does the gentleman from Michigan seek recognition?
Well, thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized for 5 minutes.
Well, thank you. I will remind my colleagues that we're not talking about Volcker rule. We're not talking about the ACA. This amendment is talking about repealing and striking all of Title X of the bill. And I'll point out that some have charged that this is somehow onerous and unprecedented. I mean, frankly, this is a modest step towards transparency that needs to happen. And I'll note that if you look at the history of the Fed, well, first of all, we, as in Congress, created it. Second of all, a number of these types of charges of intrusiveness and it being political were made during the time that they adopted Humphrey-Hawkins Act. And it was characterized the exact same way. I do want to move on a little bit to an issue, and I want to use this chart that's up in front of us. You know, the chair of the Fed, Chair Yellen, says that they use data to analyze the situation. But we don't know which data. They won't tell us what the data is. Here is data that we do know from the Board of Governors, which is their total assets. And if you look at this massive climb from less than $1 trillion to over $4.5 trillion, there's no plan to bring it down. And we saw again today where the Fed decided to hold pat on interest rates. So the question is really about transparency and what are we going to be doing moving forward. And you know, another charge that has been made is that the Taylor rule is codified in this piece of legislation. Simply not true. It's a principles-based, strategy-based recommendation. My friend from Minnesota earlier had talked about maybe they throw rock, paper, scissors to figure out what the policy is. I don't think they do. Hope they don't. Under our legislation, they actually could. They just have to tell us that that's what they're doing. And we also want to know what rules they do look at, because we know that they compare them already and they benchmark them. And if we go to the next slide, please. The simple fact is that the other charge is that, had we used the Taylor rule, the crisis would have been worse. We didn't have the Taylor rule, and look what happened with the crisis. We didn't have the Taylor rule after Dodd-Frank, and look what has happened in our recovery. And we didn't follow it before. It hasn't been followed after. In fact, the rule, the Fed hasn't deviated from any rule because they've been making it up. The frustration that I feel is that we know that the Fed looks and compares at rules and principles already. We don't know which ones. And we do know, though, that in February of 2016, a statement signed by 24 noted economists and academics, including 3 Nobel laureates, said this: "Having a strategy or rule does not mean that instruments of policy are fixed, but rather they adjust in a systematic and predictable way. In no way would this legislation compromise the Fed's independence. On the contrary, publicly reporting a strategy helps prevent policymakers from bending under pressure and sacrificing independence. It strengthens independence by reducing or removing pressures from markets and governments to finance budget deficits or deviate from policies that enhance economic stability." And if we look at that chart that we had previously up with where their total assets are, it looks like to me they have bent to the pressure from markets and from governments to finance those deficits. And so my question is, how in the world does the FORM Act threaten our recovery? The Fed had all the tools at its disposal, including ones that it made up, that it won't tell us about, and we have floundered. They have floundered. And at the end of the day, we need to make sure that we have these modest steps moving forward that lend to transparency, that we know. And let's go back to that next chart here on the latest one. This is the public debt as a percent of gross domestic product. This is not sustainable, folks. This is simply not sustainable as we are moving ahead. I have no interest in coming here and allowing us to become Greece. I have no interest in allowing us to do this to future generations. And that's why we are fighting for this legislation. We are fighting for this principle-based formula to move forward. And with that, I yield back.
Time of the gentleman has expired. Who seeks recognition? For what purpose does the gentleman from Texas seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment just maintains the status quo. I think it's clear from the last 8 years it is time to reform the Federal Reserve. But my friends on the other side have resisted reforming the Fed. Dodd-Frank gave them expansive, unprecedented new regulatory powers. The reforms, which were in the House, passed the FORM Act under the leadership of Chairman Zinda and Chairman Barr, provided much-needed transparency to an agency that has little. While the Fed has amassed $4.5 trillion balance sheet, hardworking Americans are backing failed policies. Title 10 of the Choice Act clearly allows the Fed to have transparent and predictable strategies that will benefit everyone. More importantly, and maybe more troubling, is the spike in excess reserves, as we've already talked about, held at the bank, currently $2 trillion. Large domestic and foreign banks who are privileged to receive higher rates on these excess funds have taken advantage of policies put in place by the Federal Reserve. In turn, that is money that is just sitting there, not being lent out, not serving an economic purpose. The Fed funds rate at the end of February was 66 basis points, while the interest on reserves and interest on excess reserves was 75 basis points. Clearly, the Fed has stepped well outside the bounds of a conventional balance sheet in both funding sources and size. The bottom line is that the Fed governance can be improved to get out of these distortionary rates. Let's keep Title 10 of the Choice Act. And please reject the amendment and support these common sense reforms. With that, Mr. Chairman, I yield to the gentleman from Kentucky, my friend, Mr. Barr.
I thank my friend from Texas, and I appreciate his leadership as the Vice Chairman of the Subcommittee on Monetary Policy and Trade and the great work that he's doing there. And if I could just make one additional observation, and once again to quote Milton Friedman from a speech that he delivered or an article that he wrote in 1967, but still applies equally today, and that is, that we are in danger of assigning to monetary policy a larger role that it can perform, in danger of asking it to accomplish tasks that it cannot achieve, and as a result, in danger of preventing it from making the contribution it is capable of making. And I certainly don't want to put words in the mouth of my colleagues, but I think I heard my friend from Connecticut agree with that basic sentiment. I'll let him speak for himself, but he made the point earlier that Congress and the president need to step up to conduct fiscal policy that makes sense. Now, he and I may disagree about what that fiscal policy should look like, but he's absolutely right that monetary policymakers need a little bit of humility, and that it's important that the Fed not conflate fiscal policy with monetary policy and restrain itself to focus on price stability so that monetary policy does reach its potential in terms of price stability and delivering certainty for actors in the private economy so that they can do their job. Similarly, policymakers here in Congress, we do have an obligation, as my friend from Connecticut pointed out, to deliver to the American people policies that produce economic growth. And frankly, let's look at the other side of the house of the Fed and the kind of regulatory activities that the Fed is engaging in that have canceled the accommodation and the stimulative policies of quantitative easing pursued by the Fed. Now, I don't think they're stimulative, but let's just assume, for the sake of argument, that the monetary policy that the Fed has pursued is stimulative. Even if it was achieving its objective from the standpoint of QE producing greater growth or liquidity, what the Fed is doing on the other side with regulation is self-defeating. CCAR, as my friend, the gentlelady from Ohio, was pointing out, implementation of the Volcker rule, counterproductive in many cases in terms of the complexity of the implementation of that. Oppressive supervision that really doesn't contribute to safety and soundness, but instead really imposes an excessive amount of cost on our banking system. And so even if you assume that the monetary policies pursued by the Fed were the right policies, were stimulative, and were the right approach to delivering growth, what the Fed is doing on the regulatory and supervisory side of things is certainly arguably canceling out everything that the Fed is doing on the monetary side. So let's focus on sound, stable monetary policy, transparent monetary policy that's rooted in a strategy. That I yield back.
Time of the gentleman from Texas has expired. Who seeks recognition? For what purpose does the gentleman from Massachusetts seek recognition?
Strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I actually think there's a lot of room for discussion relative to the Fed. And to be perfectly honest, I've engaged in a fair amount of that. And in the last 2 cycles, of all people in the world, Scott Garrett and I don't think we agreed on much. We filed a bill to rein in some of the Fed issues, especially when it came to 13.3, the provision that they used to drive a truck through any reasonable limitations. And yet, nobody else on your side co-sponsored that bill. So first of all, I want to go back to what was said earlier, that we just say no. Well, that's just not the case. We say no sometimes, and we try to work with others other times. And by the way, I don't think anybody here is free from the accusation of just saying no. We can talk health care, we can talk Dodd-Frank, we can talk stimulus, we can talk the action to save hundreds of thousands of jobs in the auto industry. If that's the case, you're the guys who just said no. And so don't get me wrong, there's an appropriate time and place to say no. There's an appropriate time and place to compromise. I actually think there is room for compromise here. And by the way, the last I checked, we're not Greece. We never get close to being Greece. We're not Italy, we're not Portugal, we're not Ireland, we're none of those countries. Guess what? Because of a lot of the actions the Fed took. Now, I happen to agree they probably went a little too far on certain things, and I'm happy to work with anybody who wants to work with it to try to limit some of those excesses. But the basics of what they did was right. It took Europe about a year to catch up because they thought it could all be done with austerity. And so they, let's cut everything. Didn't work. They finally figured out they had to do some investment to get themselves out of their doldrums, which is why we are ahead of them even today. So the fact that we might become Greece, I think we just went through a situation that proves we're not even close. And a lot of that credit goes to the Fed. Now again, I don't want to pretend that they are perfect or that they shouldn't be overseen or that we should do nothing, but to blame them for everything is just ludicrous. You can't find me 5 independent economists who don't work for one of the extreme right-wing think tanks who would agree with you. Again, there are things we could be doing and should be doing, but cutting them off at the knees is not one of them. And you'd best hope that this provision doesn't prevail, because the next time there's an economic crisis, there'll be nobody there who can act quick enough to save us. And that will be on you. I don't think it's going to prevail. It may prevail today in the House, but it won't prevail in the final analysis, because reasonable people think this is an extreme position. Again, if you think that's saying no, it's because you haven't talked to us. It's saying not that far. If you want to work with us, give us a call and we'll have a nice discussion. If not, keep doing things like this and we'll say no, and you'll win while you're in the majority, and if you get it passed into law, you will regret it. With that, Mr. Chairman, I will give back the rest of my time because I'm just as tired as everybody else.
Gentleman yields back. Is there any further debate on the amendment? If not, the question now occurs on the amendment offered by the gentle lady from Wisconsin, Ms. Moore. All those in favor shall signify by saying aye. All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. For what purpose does the gentleman from Connecticut seek recognition? Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. An almost sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? For what purpose does the gentleman from Illinois seek recognition? We will pause and allow the amendment to be distributed. Has every member received a copy of the amendment? If so, the clerk will report.
Amendment offered by Mr. Capuano. Insert after section 1 the following new section.
Correction, I believe this is an amendment offered by
I'm sorry, by Mr. Foster. Excuse me. Amendment offered by Mr. Foster. Insert after section 1.
Without objection, the reading of the amendment is dispensed with, and the gentleman from Illinois is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. During the previous debate, my Republican colleagues made the valid point that the Dodd-Frank Act was passed before we had access to the final report of the Financial Crisis Inquiry Commission. So my amendment, although there are findings buried various places in the Choice Act, my amendment is simply the insertion of findings based on the impact of the financial crisis on Americans and that led to the response, the Dodd-Frank Act. I came to Congress just as the financial crisis was emerging. I was on the committee during the dark days of TARP and the more promising and hopeful days when Dodd-Frank was passed. I remember hearing from Secretary Hank Paulson, President Bush's Secretary Treasury, that the financial system was on the verge of collapse. He told us that the Bush administration needed Congress to pass TARP and do it immediately to prevent our economy from collapsing within the week. And of course, it eventually took 2 votes on the floor of the U.S. House for a responsible majority to emerge to vote in favor of this, and Congress passed it and President Bush signed it. I don't think any of us were pleased at the idea of a taxpayer bailout, but we knew the alternative of total financial collapse was far worse. And even with TARP, with the American Recovery and Reinvestment Act, the auto bailout that saved millions of American jobs, and heroic actions by the Federal Reserve, the financial futures of millions of American families were irretrievably damaged. So we held 41 hearings to figure out how that could happen and what should be done about it. The reasons were numerous, as recognized in my amendment's recounting of the findings of the Financial Crisis Inquiry Commission. People were sold mortgages they couldn't afford with terms that no one could understand, including balloon payments and rate hikes, and that decent underwriting would never have projected that borrowers could repay. Regulators were focused with blinders on only at safety and soundness, were asleep at the switch for these consumer abuses, and then those consumer abuses bled back into the full economy, leading to the collapse. But the underwriters were rewarded for their origination, and the lender originating the loan was able to sell off the risk virtually immediately. The demand in the secondary mortgage markets for what proved to be erroneously rated AAA mortgage-backed securities drove further relaxation of documentation requirements. And while all this was going on, firms were also buying credit default swaps against the mortgage-backed securities. Of course, for a while, the rapidly appreciating home values made it so that homeowners could refinance before any of the terms that increased their payments hit them. But we were in an unsustainable asset bubble. And when it burst, Americans could not refinance these loans. So mortgage default rates put even the more secure tranches of these securities at risk, eventually triggering the credit default swaps. These derivatives had been sold as insurance, but the capital had not been held against them as if they were. AIG, one of the central counterparties to a large fraction of these contracts, did not have sufficient resources to pay its liabilities on them. So this failure of our financial system to avoid catastrophic risk was because these firms were taking all of the same positions at the same time. The product of the House Financial Services Committee's 41 hearings, additional hearings in the Senate, multiple markups, floor debate, and a conference committee was the Dodd-Frank Wall Street Reform and Consumer Protection Act. Having helped write Dodd-Frank, I will be the first to admit that there is opportunity to further improve it, an opportunity that's largely been squandered in the years since, as we just went into our partisan corners and we're not willing to work collaboratively to improve Dodd-Frank rather than just criticize it. Indeed, we would have been unwise to believe that any piece of legislation written on an emergency basis, as Dodd-Frank was, should be immutable in the light of changing markets and shifting economies. However, what I learned about the crisis that I just discussed can be summarized into three core themes. First, a failure to protect consumers. And so, in response to that, we established the Consumer Financial Protection Bureau. The over $12 billion return to 29 million consumers is proof of its effectiveness and the need for it. Secondly, inadequate skin in the game that drove risk-taking with other people's money. So we established the risk retention requirements for securitizations and limited the exposure of depository institutions to capital markets. Third, derivatives trading was opaque and largely unregulated. We created a framework to bring transparency to derivative markets, to incentivize centrally cleared trades, and to require margin on them. So I've worked across the aisle on risk retention, the Volcker rule, and proper allocation of risk in derivative trades. And I hope to do much more than that, but today we're being asked to throw all of the work that went into Dodd-Frank away, and as well as the bipartisan work to continue to improve it. The Financial Choice Act will, in fact, do that. And so, as a result, I think it's, going forward, it's very important for us to have a clear idea of what happened during the financial crisis. I believe the inquiry panel, the Financial Crisis Inquiry Commission, did a very good job of that, and their findings are what I wish to have incorporated with this amendment to join the other findings that are buried elsewhere in the bill. So, thank you, and yield back the balance of my time.
Time of the gentleman has expired. The chair yields himself 5 minutes. I would urge rejection of the gentleman's amendment. Certainly, I respect him so much as a physicist. I respect him maybe just a tad less as a historian as I read his amendment quickly. Again, as a matter of process, number one, to never have seen the 13-page amendment, there should not be a high expectation that we will approve such an amendment on the fly. Again, members are free to submit their amendments prior to the hearing. They are free to submit their amendments during the hearing. Lesser probability they will be accepted by the majority. Second of all, I do want to thank the gentleman for at least mentioning Fannie and Freddie in his narrative, but he fails to mention the critical role they played in the affordable housing goals that were ratcheted up, and that almost 70% of the troubled mortgages that led to the financial crisis ultimately were backstopped by the federal government, including Fannie and Freddie, when all the implicit guarantees became explicit guarantees. Next, as I read on page 6, lines 14 through 20, I do not believe the gentleman from Illinois believes that the majority would actually agree with language that somehow the Dodd-Frank Act is guaranteed to prevent a future crisis, much less that it has provided accountability or transparency. From Illinois shall signify by saying aye. All those opposed shall signify by saying nay. Nay, in the opinion of the chair, or discussion. Has every member received a copy of the amendment? If so, the clerk will report.
Amendment offered by Mr. Himes, strike section 817 through 828.
Gentleman's recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman, and I'm pleased to offer this amendment to the Choice Act, which pertains to the section of the Choice Act which would really in very significant ways reduce the Securities Exchange Commission's enforcement authority and, in my opinion, put obstacles in the way of their accomplishing their critical mission, which by the way, I think they're obviously a regulatory agency, but this is something that I think should be on the less partisan side of our conversations. The Securities Exchange Commission, of course, is the cop on the beat of our capital markets. They are there to find fraud, to identify inside traders. They sometimes do that well. They sometimes fail to do that. But it is an agency that is absolutely essential, and I know we would argue about other agencies like the CFPB, as we have over the years. I don't think there's any dispute over the fact that the Securities Exchange Commission, not populated by angels though it may be, has, since the 1930s, been a critical element of establishing the kind of confidence in our capital markets that is really essential to giving investors the trust or confidence to actually do things like invest in stocks and bonds, critical to an American competitive advantage, which is our liquid and free capital markets. I am very concerned, and to my friends on the other side of the aisle who say that we are over-hacking at this, at the Choice Act, I did look at a number of suggestions and would compliment the majority on certain ideas within their SEC title. But 817 through 828 really impose burdens and challenges for the SEC to do its mission. I want to highlight, in the time left with me, one particular thing that concerns me. I've taken a real interest over the years in the fact that we have a challenge in this country with respect to the prosecution of insider trading. Most Americans are a little startled to discover that insider trading is not in fact prohibited by law, that we have a tradition, a judicial tradition that results in prosecutions and the jailing of Americans, though we do not have a specific statute prohibiting insider trading per se. Section 819, which is one of the sections that my amendment would strike, would effectively prohibit the SEC from bringing an action against somebody, first, if they did not have adequate notice of their alleged violation of law or rule, but also because the Choice Act as written would require that the SEC, in their informing of someone they were investigating, point to a formally established rule that they would allege is being violated. Because insider trading prosecutions happen not out of statute, but out of judicially created law, if Section 819 in particular were to pass, we would have a very hard time prosecuting people or bringing civil actions against people who are inside traders. Most Americans probably would have a tough time understanding some of the actions that the SEC brings for more technical and complicated financial activities, but insider trading is pretty simple. If you've got information that the other Americans do not have, and if you trade on that information and benefit from it, you have engaged in insider trading, you have damaged the confidence of your markets, and you should be prosecuted. Section 819 in particular would make that probably, as a practical matter, impossible. So I would ask my friends in the majority to contemplate that as a possibility. Remind everyone that, again, we can have our arguments about different regulatory agencies, but hampering the cop on the beat of the health and trust in our capital markets, I would suggest, is not a constructive thing to do. And with that, Mr. Chairman, I will yield back my time.
Gentleman yields back the balance of his time. For what purpose does the gentleman from Michigan seek recognition?
I move to strike the last word, Mr. Chairman.
The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And while I appreciate the congressman from Connecticut's efforts here, we do believe that sections 817 through 828 are important. He was highlighting section 819, which is regarding adequate notice. And what we say here is that in this section, we want to provide that no person can be subject to an SEC enforcement action if that person did not have adequate notice of the law, rule, or regulation on which the action is based, provides the publication of an SEC statement or guidance constitutes adequate notice. So we believe that we cover the bases here on making sure that we're not just green lighting somehow some sort of questionable action at all by anyone in particular. In fact, what we're trying to get at is that you don't have the ability to prosecute somebody by utilizing a staff interpretation. And that's really what we have heard that is the potential here, is having somebody on staff interpret a rule or a statute and applying that. That is fundamentally unfair when it comes to due process. And we certainly do not give them the force of law at a staff level. At least certainly I would hope not that we would do that. That's our role and has been discussed from Madison on up. So in a more general conversation here about the amendment, we believe that, and I believe that Wall Street and Washington, frankly, must be held accountable if future financial meltdowns are to be averted. The Financial Choice Act increases penalties, and that is a significant part of what our Title VIII does, the capital markets improvements. Individuals that are either under investigation by the SEC or appear before the SEC in administrative proceedings must have full and complete opportunity to defend themselves. The SEC currents administrative proceedings, their in-house court system. The administrative law judges have spurned significant due process concerns and launched numerous lawsuits about their constitutionality. The Financial Choices Act's provisions afford defendants in SEC administrative proceedings a right of removal to federal court to help ensure that those defendants receive due process and eliminate the unfair home court advantage that the SEC has sought to gain by steering cases into its in-house administrative law judges. So that is something that we believe is fundamental to the discussion of this. As we just go through the various sections that the gentleman is trying to strike and eliminate, Section 817, process for closing investigations.
Will the gentleman yield for 10 seconds?
Just a moment. The closing of investigations directs the SEC to establish procedures for closing investigations in a timely manner. I'm not sure why the gentleman would like to do that. It would keep those open-ended. But you asked for 10 seconds. I'm happy to give you take 16.
Thank you. I don't want to argue with you on sort of ideology on this, but the language of 819 says that adequate notice will have been provided to a person if the commission approved a statement or guidance in accordance with Section 4I. There is no Section 4I guidance given on 10b-5, which is the insider trading route of prosecution. So I just would highlight for my friend that this will probably make civil action against insider trading impossible.
Yeah, we don't believe that. Reclaiming my time here, and I guess maybe the question would be turned around. Does the gentleman believe that a staff interpretation should hold the same standing as law?
Well, as a practical matter, it does. My observation is that this language would prohibit such staff interpretation from being used in the case of insider trading.
Reclaiming my time, but you see the problem there. We have staff interpretation going in while it is not based on statute. It's not even based on rule. It's based on interpretation of what the staff is moving forward. So, but just real quickly, we are trying to have an enforcement ombudsman in Section 818, an advisory committee in Section 820 on commission's enforcement policies and practices, 821 process to permit, and hopefully I'll be able to get one of my colleagues we can revisit these. So I yield back.
Time of the gentleman has expired. For what purpose does the gentleman from Washington seek recognition?
Move to strike last
The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Sure been a lot of disagreement over the last couple of days on a whole host of issues, most especially the one I have followed is disagreement over what actually caused the Great Recession. Frankly, I'm tired of that debate. We're talking past one another. We're never going to get there. Let's move on. One of the places that we could move on to is where do we agree? And it seems to me that it's pretty clear we agree on a couple of things, that this was a man-made crisis. This was no natural disaster that caused these millions of jobs to go away or these trillions of dollars worth of net worth to evaporate. And we can also probably agree that pretty much nobody was held accountable. Virtually nobody was held accountable. And I think that's the point here. The truth is that I've observed, been a party to, been involved in very few issues in the course of my entire adult life where I thought what happened just sticks in the craw of the American public, like the failure to hold anybody accountable for the Great Recession. It's as though people feel that they got away with murder. They got away with murder. And this was really brought home to me by a couple of instances, one just yesterday. One earlier than that, I was actually sitting in the office of one of my local, fairly good-sized community bank presidents. And when he was talking about people getting away with murder, he got red in the face, and he got emotional, and I know what he was thinking. You know, if I did anything like that, operating my community bank, they'd take my charter away and I'd be in jail, and these guys got away with it. And the other thing I think that helps explain why this sticks in the craw of so many people is, if you listen to my colleague from Nevada yesterday, Congressman Cahune, about the Estrada family, and they lost their home. And there's this sense of, where's the fairness? This isn't fair. These people lost their homes, And yet these other people over here were a party to inducing this, and they weren't held accountable at all. And frankly, that's why I support Mr. Himes' amendment to reverse the weakening of the securities law enforcement and penalties section of this. In fact, later I'll be offering my own if I have time on the banking side. You know, we had a hearing on a bill a week or so ago, and the entire table was filled with majority party witnesses, save one. Some of you may remember this. I asked the following question: who here thinks that a problem of the last 10 years is too much investigation of financial crimes and abuses, that too many people have been punished for precipitating the financial crisis? If you agree with that, raise your hand. Crickets. Not a single hand went up. And then frankly, that's why I'm baffled, why you would want to take such giant steps backward and make it so much harder to investigate financial crimes and abuses. Who says we have too much of that? Section 512 constrains the DOJ's subpoena powers under FIREA. Remember FIREA, we passed that in the wake of the savings and loan scandal, and that office has accounted for tens of billions of dollars of recovered money. 817, been referred to, requires SEC to time limit their investigations. Well, come on. We all know what's going to happen. Talk about setting up an incentive to drag your feet and not cooperate. 826 puts time limits on SEC subpoenas. Same thing will happen. So there's been a lot of citation here of the increased penalties, but I'm here to tell you, if you take the cop off the beat, or if you put handcuffs on the cop, or harness the courts, the reaction's going to be pretty obvious. A big collective sigh and go ahead, break the law. If you do, you won't get caught. That's the sign we're making. That's the message we're sending. And oh, by the way, if you do get caught, you won't get punished. That's not the message we need to be sending. People feel as though there is a fundamental issue of fairness that has been violated. And 8 years later, it sticks in their craw. I thank Mr. Himes for offering this amendment, which is to get rid of all these obstacles for pursuing the truth and take the shackles off SEC to do their job. And I strongly hope and urge my colleagues to vote for it. Nobody is calling, in my congressional district, nobody's calling for us to get soft on financial crime. This bill would. Don't go down that path. I yield back the balance.
Time of the gentleman has expired. For what purpose does the gentleman from Minnesota seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I guess if you don't like the fundamental constitutional protection of constitutional protections that are afforded to all Americans, you're going to like this amendment.
Okay.
I mean, if you aren't interested in providing equal protection under the law, you're going to like this amendment. If you're not interested in the constitutional right of due process for Americans, you're going to like this amendment. This is crazy. This flies in the face of the most fundamental tenets of the American justice system to suggest that we shouldn't put government in a place where it has to justify its actions against American citizens. I mean, this was the topic, by the way, of the last election. It's this condescending attitude from Washington that we're going to protect government at the expense of the American people. And this is where the forgotten men and women of this country got upset and said, we've had enough of you folks in Washington, D.C., who continue to pat us on the forehead and tell us there's nothing to see here, folks. Everything's good. We'll take care of you because we know what fairness is. We define fairness. We define justice. This is a crazy amendment. I mean, if you favor government over people, vote for it. I mean, it really gets down to what appears to have become a fundamental difference between the two parties in this country. We got one party that tells the American public they're going to protect them, they're going to take care of them, they're going to make sure that they're never going to have any conflict in their life. But the way they do that is by taking away their basic freedoms and not protecting them when it comes to their constitutional right of due process. And then you got another party that's saying, you know what? We believe in due process. We believe that the government that has all the power, all the tools, needs to be held in check. This is just the most basic rights that you are seeking to strike in this amendment. And that's why it makes absolutely no sense to support something like this unless, frankly, you're just not interested in the constitutional protections that are supposed to be afforded to all Americans. And Mr. Chair, if I can, I'd like to yield to my friend from Michigan at this point.
Well, I appreciate my friend for doing that. And I do want to revisit to your 819 and correct something. Insider trading is against the law pursuant to statute section 10B and the SEC rule 10B51 and 10B52. And the SEC adopted new rules, this 10B51 and 10B52, to resolve two insider trading issues where the courts have disagreed. Rule 10B51 provides that a person trades on the basis of material non-public information if a trader is, quote, aware of the material non-public information when making the purchase or sale. The rule also sets forth several affirmative defenses or executions to liability. The rule permits persons to trade in certain specific circumstances where it is clear that the information that they were aware of is not a factor in the decision to trade, such as pursuant to a pre-existing plan, a contract, or instruction that was made in good faith. Rule 10B52 clarifies how the misappropriation theory applies to certain non-business relationships. This rule provides that a person receiving confidential information under circumstances specified in the rule would owe a duty of trust or confidence and thus would be liable under this misappropriation theory. So the SEC adopted rules 10B51 and 10B52 after first publishing its proposed rule, which was open to notice and comment, that's under the Administrative Procedures Act, and then the SEC adopted the final rules. The SEC last amended SEC rules 10B51 and 2 in 2000. Again, the SEC adopted these rules and amended these rules in accordance with the Administrative Procedure Act, and individuals were put on notice about the law. And what we're saying here is that you can't have staff just decide that they're changing their mind without going through proper notice, without going through the rule of law, without going through the procedure that has been laid out. And why in the world we would want to strike that, I don't understand. In the last few seconds here, I'm baffled why we would want to eliminate an advisory committee on commission enforcement policies and practices. Why in the world would we not want to have publication of an enforcement manual that directs the SEC to publish a manual setting forth policies and procedures that it follows in enforcing the securities laws? It directs the SEC to publish annually an enforcement plan and report that sets forth the SEC's enforcement priorities. So I look forward to revisiting this.
Time of the gentleman from Minnesota has expired. Who seeks recognition? For what purpose does the gentlelady from New York seek recognition?
I move to strike the last word.
Gentlelady's recognized for 5 minutes.
Thank you. Thank you so much, Mr. Chairman. And I support this amendment, which I am proud to co-sponsor with my good friend from the great state of Connecticut, Mr. Himes. This amendment would get rid of 12 different harmful provisions, which taken together would cripple the SEC's ability to police bad actors in the market. As Mr. Himes noted earlier, Section 819 of the bill would make insider trading prosecution very difficult, which should be troubling to everyone in this room. Section 823 is also a huge problem in my view. It would overhaul the SEC's administrative courts by permitting a defendant, rather than the SEC, to choose the venue of an enforcement action, essentially whether the enforcement action is initially tried in an administrative forum or a federal district court. Currently, when the SEC is bringing an enforcement action against a bad actor, it can choose the venue that best serves the interest of investors and the public. A defendant in an enforcement action, on the other hand, would likely choose the venue that is in the defendant's best interest. So this section would essentially give bad actors a head start in enforcement cases with the SEC. For example, this section could potentially allow a well-funded defendant to choose a district court venue, knowing that the federal district courts are often overwhelmed, which may delay the trial for years. This is hardly the way to maintain confidence in our markets. It's also important to remember that the SEC has long had the authority to try certain cases in an administrative forum rather than in federal court. And we simply expanded this authority in Dodd-Frank because it's been such a useful tool for the SEC. People forget that much of our insider trading law was developed in an administrative case. The insider trading case of Katie Roberts in 1961 was an administrative opinion, and the Supreme Court later adopted much of the Katie Roberts analysis as the basis for insider trading law. I think the SEC's administrative forum has been a very useful tool, and I'm extremely concerned about making changes that could weaken the enforcement of SECs, as well as their ability to quickly and fairly prosecute wrongdealers and wrongdoers. I've always said that markets run much more on confidence than on capital. And in order to maintain confidence in our markets, we need a tough, credible cop on the beat, and that cop needs to have the necessary tools to bring bad actors to justice. This amendment would restore these vital tools. I congratulate my colleague, Mr. Himes, on his amendment. I urge my colleagues to vote for it, and I yield my remaining time to Mr. Himes from Connecticut.
Thank you, and I thank my colleague and neighbor from New York, and just want to reiterate, this is ultimately a matter of legal interpretation, but I think it's a big deal, and I personally care about it because in the last two Congresses I have offered legislation which would, for the first time, define in statute the crime of insider trading, which is currently not defined in statute. Insider trading is prosecuted pursuant to judicial history and judicial precedent, starting with the Dirks case. And relying on 10b-5, but I will say it again because I think this is important and should be some source of bipartisan agreement that Section 819 will remove the ability of the SEC to rely on the judicial interpretation that they have always relied on. So I would say two things. Number one, to be cautious about that. Number two, I would urge the majority to help clear this up by joining on my insider trading legislation. I am of the belief that if we are going to send people to jail, we ought to have a actual statute which gives the government authority to do that. I am sorry that Mr. Emmer has left. I might not raise this were it not my amendment, but Mr. Emmer, in what was otherwise a pretty interesting conversation, called this attempt crazy, unconstitutional, condescending, and taking away basic freedoms. I would like Mr. Emmert perhaps to dive into the actual substance of this stuff, to consider whether that kind of toxic ad hominem attack actually adds anything to an important debate, and join me in actually making some progress on this issue. With that, Mr. Chairman, I yield back.
Time of the gentlelady from New York has expired. For what purpose does the gentleman from Illinois seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Again, I think this is an important discussion to be having. Certainly all of us agree that the SEC, its primary focus needs to continue to be that vigorous enforcement of federal securities law. We need to make sure it has the tools to do that, to punish wrongdoing wherever possible, to make defrauded investors whole. But the SEC also really needs to strike that right balance between deterring and punishing securities fraud and protecting shareholders from paying unnecessarily for the sins of rogue corporate officers or employees who've rarely been the subject of disciplinary action there. By requiring the SEC to incorporate economic analysis of its deliberation on enforcement matters, which is in this section and that this amendment would remove, unfortunately, this amendment would take away that protection that shareholders' interest would be recognized, protected to a greater extent than is currently the case. Also, this amendment would remove, if it's included, would remove the new requirement that the SEC chairman convene this new committee with that same mission of the original Wells Committee in 1972, which reviewed the SEC's enforcement program and offered recommendations for the Commission's review. This is, I think, a really important holistic review of the enforcement program to ensure it comports with both the SEC's mission to protect investors, maintain fair, orderly, and efficient markets,
and facilitate capital formation and our constitutional due process rights. That's the most important thing we're talking about here, is making sure that the rights of individuals are protected, that there's not an assumption of guilt, or that the power of government is being forced or misused. Inclusion of provisions to ensure investigation enforcement process in the SEC, making sure that they're transparent and accountable, I believe really are paramount to make sure that this fair treatment continues or is once again recognized for those being subjected to the agency's sweeping authority. And it really is significant authority that the SEC has. Our committee has heard significant testimony over the last few years regarding multiple overreaches by the Securities and Exchange Commission, specifically in this area. In the last week's hearing on the Financial Choice Act, we heard testimony from Hester Pierce, Director of the Financial Markets Working Group at the Mercatus Center, and she said, and I quote, "SEC reforms such as requiring transparency regarding enforcement practices, expanding opportunities for parties to present their positions in person, and allowing parties to opt out of administrative proceedings and into district court will help to assure the public of the objectivity of the SEC's enforcement program without compromising the SEC's ability to successfully bring enforcement actions. Again, other financial regulators would benefit from similar reforms," end quote. So I really think these reforms in the Choice Act are very important, and unfortunately the amendment by my friend from Connecticut would strip out many of these important protections for shareholders, recognizing, again, important constitutional protections that need to be a part of this, and some of the overreach that the SEC has admittedly done over the last few years, and both sides of the aisle here today have recognized that. I also believe that this makes enough sense that similar reforms ought to take place for other market regulators. One, for example, CFTC, Commodities Future Trading Commission, I think would make sense for them to adopt many of these changes that we're offering in the Choice Act as well. Since CFTC is not under the jurisdiction of our committee, I hope that down the line we can work with the acting chairman of the CFTC, Giancarlo, Chairman Conway, and our colleagues in House Agriculture Committee to try and make some of the changes in there as well. Again, this is the right thing to do. It's protecting investors, protecting shareholders, making sure that the process works, making sure that there's not an abuse of government power. And so I'm opposed to the gentleman's amendment. I think the reform in Choice Act is the right way to go, and will again redirect the SEC back into the important role, function that we need it to accomplish, but to do it within the constraints of openness and transparency and making sure that constitutional rights are protected always first and foremost.
Well, gentlemen, yield.
With that, would yield to my chairman of the Capital Markets Subcommittee from Michigan.
Thank you. I appreciate this, and quite honestly, we have 591 pages here. I do not know how you people did it under Dodd-Frank with 2,300, where this is unwieldy enough. But you go back, look at page 438. That's where we hit section 819 as it goes on to page 439. I mean, this is about accountability. It lays out how this is supposed to work. And you know, I'm happy to work with the gentleman from Connecticut and take a look at his insider trading statute and codifying this. But the point was that was made earlier, Mr. Chairman, was that there was no rule under this, and that it was like the wild, wild west, and that simply isn't the case. What we need to do is make sure that we have accountability with traders and the SEC, and I yield back.
Time of the gentleman from Illinois has expired. He seeks recognition. For what purpose does the ranking member seek recognition?
Move to strike the last word.
A gentlelady is recognized for 5 minutes.
Thank you very much. If you listened to my Republican colleagues and didn't read the fine print, you may think that the Wrong Choice Act would, quote, demand Wall Street accountability and give the Securities and Exchange Commission the, quote, toughest penalties in history, end quote. But you would be mistaken. Instead, the bill actually contains a variety of provisions that would slow down and hamper the SEC's investigations and enforcement activities so that the agency would have a much harder time imposing any penalties at all. For example, the bill would allow defendants to opt out of enforcement proceedings in the SEC's administrative, in-house courts and require the agency to take its case to federal court. While this may seem insignificant because of how busy federal courts are, it would allow the case to drag on indefinitely, sometimes for decades, while the defendants continue to scam investors. In addition, the Wrong Choice Act forbids the SEC from banning bad corporate officers and directors from the industry, which means that repeat offenders would be allowed to continue to hurt investors without consequences. To put this in perspective, this bill would allow Bernie Madoff to open up shop once more to swindle investors and seniors if he was out of jail. I fail to understand how allowing criminally convicted CEOs to remain in their position, quote, creates hope and opportunity for investors, quote, end quote, which is the misleading title of this horrible bill. The bill's increased penalty authority does not make up for this repeal, since penalties are easily affordable for wealthy offenders or may be totally ineffective when an offender has no money. I agree with Professor Michael Barr from the University of Michigan Law School, who testified that Wrong Choice Act, quote, hamstrings SEC enforcement against bad actors and frees fraudsters to prey on investors once again, end quote. So I thank Representative Himes for offering this amendment to strike all of these harmful provisions and urge members to join me in supporting it. And I yield back the balance of my time.
Gentlelady yields back. For what purpose does the gentleman from Wisconsin seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I am speaking in opposition to this amendment, and I just would note that I know that Mr. Himes is incredibly thoughtful and has a great deal of knowledge in this space, and has been a good partner trying to think through some big issues that take place in this committee. But I do have concerns with this amendment, and frankly, some of the comments that were just made by the ranking member, who I like very much, but though we probably don't agree on a whole lot politically. She's talking about these sections hampering an investigation. So if you have your judges, your ALJs that are employed by the SEC, and you have a 90+% conviction rate, and we're asking that we have an escape valve to go to our federal court system, yeah, that might hamper in prosecutions. I mean, as I was a former prosecutor for 10 years, and man, if you didn't make me use the county elected judge, and I was able to get an ALJ that was employed out of the DA's office, I bet I would have a lot more convictions, and I'd be a lot more efficient in convicting people. I could be the one-stop shopping. I would charge, I would decide, and I would execute, and I'd be a big winner. But we believe in a constitution. We believe in due process, and that there's opposition to letting our federal courts take these cases instead of SEC-employed ALJs is a little bit shocking to me. Again, the systems and the rules by which we play are important. And we have had a lot of conversations and testimony on this very topic, and I believe in due process, and I believe in fair and impartial judges making decisions in these cases. I also have, my friends across the aisle have issue with a process for closing investigations. If you've ever been investigated, which I have not, but you talk to those who have, you drag these cases on and they never close, and they grind people down. They almost grind people into settlement just to end the case. Why don't we have a process for, let's investigate people and let's make decisions in these cases. Let's not drag them on forever. I don't know why my friends would be opposed to that. To have an enforcement ombudsman, where we have a valve to go to. We have this all over government, and especially in banking. I don't understand the opposition to that as well. I mean, adequate notice of investigations? I mean, this is common sense stuff that I'm surprised that out of all the text of the Choice Act that my friends could choose to offer. I don't know if we're going to get through, 10 or 12 amendments in 2 days? But of all the amendments that you could offer, I'm surprised that this would be one of them. And to follow up on one last point, and I want to then yield to the gentleman from Michigan, we do have the strongest civil and criminal penalties in history. So we are making sure we have a process and penalties to take care of the bad actors who abuse the system, which I think is incredibly important. With that, I will yield to the gentleman from Michigan, Mr. Hesinger.
Well, I appreciate my fellow sub-chair for doing this, and as he points out, a number of these things are common sense, I think. It's about accountability. And when you're hearing, again, some of the hyperbole coming from the other side, we have to do some fact-checking here. This is about accountability of both traders and the SEC. And as you were pointing out with these administrative law judges, the ALJs, the system, they bring the prosecution, they do the prosecution, and somehow we're shocked that there's a 90% success rate. I mean, they have one significant exception when they went after a well-funded accusant who said, you know what, I'm going to fight back, and they exposed the kangaroo court nature of the ALJ process. And if it wasn't for them, they'd still be touting this 90% success rate. Instead, we have a tilted playing field right now. And the purpose of the ALJs originally was to deal with highly technical issues. And we've moved well beyond that. Thank you, Mr. Chairman.
Time of the gentleman from Wisconsin has expired. Who seeks recognition? For what purpose does the gentleman from Ohio seek recognition?
Thank you, Mr. Chairman.
Move to strike the last
Move to
word.
strike the-
The gentleman is recognized for 5 minutes.
Thank you. I just wanted to speak about due process here. And I was encouraged listening to my colleague from New York speak about the cop on the beat and support for law enforcement. And I think it's a nice reference because cops on the beat don't get to serve as prosecutors and judges and juries. They get to point out violations of the law and enforce the law. I was also encouraged by my colleague from Connecticut referring to the courts and, frankly, support for insider trading being prosecuted. And so I hope that it's a bipartisan sense that we embrace due process, which it should be since it's in our Constitution. And I think the concern is that the SEC is abusing the Administrative Procedures Act by the way they've used administrative law judges. I want to point out some of the key differences on the slide between the federal district courts and the SEC's current administrative proceedings. These things, these protections, and numerous references, including from our ranking member, about their concern that these wealthy defendants can have access to the courts. And I think that's pertinent because only a wealthy defendant could afford to try in the current system to get to the courts through the plethora of steps. The federal court, unlike federal court cases seeking penalties in which following the opportunity to take full discovery, i.e. everything, including depositions of all key individuals, a defendant has a right to a jury trial presided over by a neutral federal judge. Administrative proceedings are before an administrative law judge, a commission employee who renders an initial decision that is subject to an appeal to the employer, the SEC. The commission, which itself the administrative is bringing the complaint, and an unfavorable commission decision being subject to appeal before the U.S. Court of Appeals. And in that process, Mark Cuban is a recent example. Deep-pocketed, not known as a right-wing guy in very many circles, but he was able to go through the district courts and challenge, and what he found or what I should say, what the jury found, is that he was not guilty. And he had the deep pockets to be able to do that. So a less well-funded individual or a less well-funded corporation is pressured under the current process to basically beg for mercy under the central planner that serves as the cop on the beat, the prosecutor, the judge, and the jury. Here's what the jury forewoman said: the case was not as strong as persons with the SEC thought it was. And that was possible to know because of these key differences that came out in a trial. And in our system of justice, we embrace due process, and certainly we do want, as the Choice Act does, bring stiff penalties. It makes clear that we should not accept violations of the law. We should go after people that lie, cheat, or steal in order to take advantage of others. And so this due process clause allows that to happen in a way that is fair, it's constitutional, and it respects the laws and practices of our country. It, in fact, unlike the SEC's administrator, allows the law to be applied, where the SEC doesn't necessarily have to be constrained to that. So I think it's an important part of the Choice Act. The whole act has lots of good things. I look forward to collaborating with our colleagues on all sides to make continuous improvement to the laws of our financial sector. With that,
Would the gentleman yield to the gentleman from Michigan his remaining time?
I yield the balance of my time to the gentleman from Michigan.
I appreciate that, and I just wanted to quickly to point out a couple of things. First and foremost, the Choice Act includes the toughest penalties in history for those on Wall Street who break the law. It increases civil and criminal penalties to their highest levels in history because we must ensure that consumers and investors are protected and treated fairly and have access to competitive information. But this home court advantage element, we want the SEC to prosecute securities laws violations. However, we want to ensure that the SEC proves its case and that respondents are entitled to their constitutional due process protections. And providing a right of removal for respondents in administrative proceedings is necessary to restore the proper balance between the ALJs and the district judges. So thank you, Mr. Chairman.
Time of the gentleman from Ohio has expired. Who seeks recognition? Is there any further debate on the amendment? If not, the question now occurs on the amendment offered by the gentleman from Connecticut, Mr. Himes. All those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. For what purpose does the gentleman from Connecticut seek recognition?
Mr. Chairman, I request a recorded vote.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. Sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, for the proceedings on the amendment are postponed. Is there further amendment or discussion? For what purposes, gentlemen from Washington seek recognition?
I have an amendment on the desk, Mr. Chairman.
We will pause and allow the amendment to be distributed.
So I made a real effort. Thank you.
Has every member received a copy of the amendment? Has any member not received a copy of the amendment? So the clerk will report.
Amendment offered by Mr. Heck, page 96, line 10, insert before the period the following, or on the motion.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment, which I'm proud to sponsor along with several of my colleagues, Ms. Beatty, Ms. Velasquez, Mr. Gonzalez, and Mr. Chris, combines two things I've worked on since the very first day I arrived in Congress: service member protection and financial literacy. And if you've spent any time in this committee, you know two things about me. I'm enormously proud to represent the 55,000 people who report to Joint Base Lewis McChord every single day. and I am an evangelist for those who stand up for their interest at the CFPB's Office of Service Members Affairs. Well, today, you don't have to hear that from me. You have to hear it from 22 organizations representing veterans and military families. Their letter to the Committee on the Office of Service Member Affairs ends as follows. The CFPB's work to protect, assist, and educate military families in the financial sphere is paying dividends for our nation's military personnel readiness. We urge you to continue to support the work of the Consumer Financial Protection Bureau and its dedicated military office. You know, ever since Holly Petraeus stood up what we call OSA, it's been working to provide education and financial literacy, coaching, and decision-making support tools to service members who are facing financial decisions. But once OSA built out products that covered CFPB's core areas like loans and credit reports, they began engaging in partnerships with other agencies and expanding their effort to develop comprehensive education tools. One decision, or one example, is OSA's engagement with the SEC, which has built out investor education resources specifically targeting the military. Well, what this amendment would do, to finally get to its substance, is to codify and, yes, slightly expand, and most importantly, protect these service members' education efforts. It does so by doing three things. It adds a new section that creates a new Office of Service Member Protection at SEC. It, secondly, strikes the portion of Section 722 that guts the Consumer Bureau's Civil Penalty Fund. That fund repays victims and uses any surplus for financial education, much needed literacy. The first education project funded under this authority was the Financial Coaching Initiative that provides in-person education and counseling to vulnerable populations with, of course, a particular emphasis on service members. And lastly, it modifies Section 215 of the bill to allow the SEC's Civil Penalty Fund to fund financial education, just like at the Consumer Bureau. The work done by Holly Petraeus in standing up the OSA has been a tremendous credit to her and a great benefit to the community that she serves. As many of you know, Holly began her well-deserved retirement at the end of last year. We all, of course, wish her well. But her successor, retired Colonel Paul Cantwell, is impressive in his own right. I've had the opportunity to sit down and meet with him and ask him about his plans for the Office of Service Members Affairs, and I would strongly encourage each and every one of you to do that as well. This bill, however, if it is not amended, would hamper Mr. Cantwell's plans and damage further financial education efforts. You know, I'm reminded of our dear friend and retiree, former colleague, Ruben Hinojosa, who rarely let a single meeting go by that he didn't bring up the dire need to create more financial literacy and education programs in this country. So many of our problems could be solved if we put the right tools in the hands of people to make good financial decisions, good financial plans for themselves. That's what this amendment is about. I believe that it's not just a mistake, but contrary to the will of the committee if we do not amend it. I encourage my friends to join together to preserve financial education and to protect service members and build upon our success to expand these efforts to the SEC so that we might also enable them to have a fulfilling adulthood of good financial decisions. I remind you all as well, as I did a couple of weeks ago, it's easy to have our service members top of mind when we have more of them currently engaged in theater. But the fact of the matter is every day they get up and put on that uniform, they're willing to make that sacrifice. We should think no less of them. We should keep them top of mind and pursue efforts such as this. With that, I yield back, Mr. Chairman.
Time of the gentleman has expired.
Mr. Chair.
He seeks, for what purpose does the gentleman from Michigan seek recognition?
Mr. Speaker, I'm sorry, didn't mean to upgrade you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized for 5 minutes.
These days, I'm not sure it's an upgrade anyway, sir. I do want to address a couple of things, and before we get into what I believe is probably the meat of the gentleman's intent on the amendment, I do want to address something else that is maybe a little bit of a stealth move on his part or somebody's part of striking Section 722 of the bill, which is to reform the Consumer Financial Civil Penalty Fund. That is the slush fund that the CFPB has control over. And what it says...
Will the gentleman yield?
Not quite yet. What it says is that the CFPB has 2 years to identify victims, or that money reverts to the Treasury. And we felt that that was important. So I will yield to the gentleman for an explanation as to why 722 is included in this.
So what I'm really interested in asking the gentleman from Michigan is how you would characterize this effort as, quote, stealth, when what I said, and I quote myself verbatim, it strikes the portion of the section of 722 that guts the Consumer Bureau's Civil Penalty Fund. What about saying that suggests to you that this effort is stealth? I was transparent.
Sorry, I didn't mean to be so nefarious.
So you weren't
reclaiming
listening.
my time.
You weren't listening.
Reclaiming my time.
Okay.
To the gentleman from Michigan.
I'm curious as to why Section 722 would be inserted into an amendment that is largely focused on Veterans Affairs, but that's something that the gentleman can use.
You want me to answer that question?
That's something that somebody else's time can be eaten into to discuss. What we have here is the SEC has a tripart mission: protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. Pre-Dodd-Frank, the SEC had an Office of Investor Education and Advocacy, which provides a variety of services and tools to address the problems and questions that investors may face, and has dedicated funding for investor education and financial literacy. Title IX of Dodd-Frank created the Office of Investor Advocate, which, according to the Commission, has 4 core functions: 1, to provide a voice for investors; 2, to assist retail investors; 3, to study investor behavior; and 4, to support the SEC's Investor Advisory Committee. Additionally, the Boston Consulting Group study, which Dodd-Frank had mandated that be done, which was basically shelved, I might add, after they had completed it, after millions of dollars of being invested into it, says that there's too much already going on at the SEC, and that the Boston Consulting Group is saying, you know what, these types of things, adding additional things, could pull the eyes off of the SEC's initial mission. But let's not just curse the darkness. Let's light a candle. I believe the gentleman from Washington is attempting to do that, Section 722 notwithstanding. But if we're talking about this for veterans, I think that what we can do and work together on is requiring or talking to and discussing with the Office of Investor Education and Advocacy and with the Office of Investor Advocate to have a focus on that, to take that those resources that they have, to focus that in on our men and women in uniform who are coming back, to make sure that they are informed and educated and that have every opportunity to utilize the tools that are already there. I'm just not convinced that there needs to be an additional new office created in the SEC. I'm afraid that they're already doing a number of other Dodd-Frank directed social engineering type of things with conflict minerals and CEO pay ratios and others that have already pulled their eyes off of their tripart mission. And again, that's to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. Maintaining fair and orderly and efficient markets. The fair part clearly was what was part of the Office of Investor Education, again, pre-Dodd-Frank, and the Office of Investor Advocate post-Dodd-Frank. So I guess I would encourage, I oppose the gentleman's amendment, 722 being one of those issues, but the rest of it I'd like to work with him on to see if we can work together to advocate for those that you were trying to advocate in this particular amendment with doing it in a different way. With that, I yield back.
Time of the gentleman has expired. For what purpose does the gentlelady from New York seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you. Let me thank the gentleman from Washington, Mr. Heck, for offering this important amendment, which will build on the important work already going on at the SEC, the DOD, and the CFPB to provide financial literacy and financial education to America's service members and other vulnerable populations. Last month was Financial Literacy Month, something we need to be promoting year-round. Teaching sound financial literacy starts at an early age. Learning to manage your money well is essential to achieving freedom, independence, and success. Individuals with greater personal financial knowledge at a younger age are more likely to have positive personal financial experiences and save for retirement. Yet, most young adults receive no financial education before they enter the workforce. 39% of American adults have zero non-retirement savings. 56% of American adults do not have a budget, and 76% of college students wish they had more help to prepare their financial futures. Research has shown that financial literacy programs make a real difference in overcoming these hurdles. But it is also important to promote financial literacy among adults in order to help Americans save for retirement. Retirement security is a universal goal for most Americans, and it is important that all Americans are adequately prepared. Baby boomers are beginning to retire en masse, and many are not financially prepared for retirement. For example, only 16% of Americans demonstrated a relatively high level of personal financial knowledge and understanding. Part of being prepared for retirement is understanding basic financial concepts. Ignorance about these concepts affects retirement planning and participation in the stock market. Financial literacy affects critical decision-making for retirement and can help adults comprehend risk and return. In fact, comprehending risk and how to diversify is one of the lowest areas of personal financial knowledge among adults. While we have taken steps to improve financial literacy, we must do more to give individuals the tools to succeed in retirement. Because when we invest in people, they can invest in and for themselves. Helping baby boomers and all Americans learn financial literacy concepts can set them up for much richer retirement. I will argue this is also create greater financial stability for all Americans. Once again, I want to thank my good friend, Mr. Heck, for offering this important amendment, and I urge the members of this committee to support it. Thank you.
Gentlelady yield back. Gentlelady yields back. For what purpose does the gentleman from Missouri seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The gentleman from Washington is a good friend, and I appreciate all his efforts, and I certainly don't necessarily disagree with his attempt to try and help our veterans. I think it's a very worthwhile and noble thing for him to do. But striking Section 722 of the Choice Act is no-no, my friend. That is something that's in there for the benefit of the citizens of this country that have been wronged, that we don't want those monies to pile up with an agency that doesn't seem to be able to work with them. And if you look at what actually the fund's all about, it's monies that are deposited in the Federal Reserve Bank of New York that's to be administered by the Bureau to be used for compensating victims for harm that they've incurred. And the structure of the penalty fund is unique in that the Federal Reserve, OCC, and FDIC all turn over their unobligated penalty funds to the Treasury, providing direct benefit to taxpayers. This bill brings the CFPB into line with the common practice that's followed by all these other financial agencies. We should be able to agree that when the Bureau obtains a penalty, that penalty should go to the victim, not to some special interest group. This bill simply provides the CFPB with proper incentives to ensure that civil money penalties go to the victims. And in the bill itself, the 722, it states that not later than 60 days after the date of deposit, the agency shall identify the class of victims of the violation of consumer financial laws for which such amounts are to be collected and deposited in the paragraph. Next line explains how they're supposed to be paid out within 2 years after the date. And after 2 years, if they still are there, the victims haven't been found, no other practical use of those funds can be utilized, they then escheat to the Treasury. Now, this is not something in my mind that's uncommon, in that back in my home state of Missouri, we do this very same thing with unclaimed funds. Our state treasurer holds it on the books, or the physical asset itself, whatever it is, it's unclaimed, for a period of time. It's usually around 2 years, and then either sells the asset that is sitting there, or the funds themselves will escheat to the state. To let that money sit there is a temptation for bureaucrats to have a pot of money to play with. And while I often appreciate my good friend from Washington's hard work here, the Bipartisan Policy Center made the comment that said, the CFPB's administration use of funds that have accumulated in the civil penalty fund beyond those necessary for consumer redress should be more specific and transparent. The existence of such a civil penalty fund also could represent a conflict of interest for the Bureau, given its ability to use these funds for its own purposes. That's the purpose of Section 722, is to give some direction to the CFPB on how these funds are to be utilized, how you differentiate them from others, how you make payments from the fund, and when after a certain period of time when those funds are can no longer be dispensed to the victims because they can't be found or more money was accumulated than what was in the fund, those funds then should escheat back to the Treasury. I'm flabbergasted that my good friend would do something like this, because I think this is just good common sense, a way of handling these funds. I don't think a slush fund of CFPB of all agencies is the one that we need to be involved with here. So I certainly do not support the gentleman's amendment, and believe 722 in our Choice Act is extremely important. And I'll yield to the gentleman from Michigan, the Capital Markets Chair.
I appreciate that. And turns out that what I was discussing regarding the SEC dealing with the military is already happening. And it's called Operation Invest Wisely. The SEC, through its Office of Investor and Education and its 11 regional offices, participated throughout the country in programs and initiatives. Oh, by the way, this is off the SEC website. And it says that they are interested in additional opportunities to help educate members of the military. So I'm not sure if the gentleman was asserting that the last administration failed in its duty to do so, or maybe he, like me, was unaware that they were actually doing that and that was a stated goal. But I guess it does beg the question, if that has already been thought about and is been put into place, why would we go and create another silo if the SEC, under the last administration, had an effort to do so already? With that, I yield back.
Time of the gentleman from Missouri has expired. For what purpose does the gentle lady from Ohio seek recognition?
Thank you, Mr. Chairman. I guess we're going to prolong this, and this is another, is the glass.
Gentlelady, move to strike the last word.
Move to strike the last word.
The gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I guess this is going to be another case of, is the glass half empty or half full? And I certainly have an appreciation for what my colleagues have said, but I support this amendment and sponsor it with my colleague because I believe in looking at what is in the language of Dodd-Frank in Section 722 and the purpose of it, that it is not a no-no, but it is a yes-yes. Because Section 722 of this bill would essentially eliminate the funding for consumer education and financial literacy programs that the Consumer Bureau invests in each year. And it states that in the legislation that it could be used for consumer education and for veterans. The funds left over in the Civil Penalty Fund pay for more than 60 certified financial coaches around the coaches who team up with organizations to provide one-on-one counseling to assist our constituents meet their financial objectives. Specifically, this provision would cripple the Consumer Financial Protection Bureau's efforts to sponsor financial literacy programs that provide financial coaching services to transitioning veterans and economically at-risk consumers. And according to the National Foundation for Credit Counseling, veterans are nearly twice as likely to carry debt from month to month than other civilians. And with 250,000 service members transitioning from active duty to civilian life each and every year, it is imperative that we receive adequate financial counseling to assist them assimilate back to their everyday life. I could go on and give you other information, but in 2015 alone, the Consumer Financial Protection Bureau's Office of Service Members Affairs collected nearly 20,000 complaints from service members. So to my colleague who implied or said, were they not doing their job? Clearly, I think they were doing their job in using these funds to take care of those constituents who belong to both of us. I belong to the Bipartisan Financial and Economic Literacy Council, and one of the things Congressman Steve Stivers and I have seen firsthand is the number of veterans who need this service, so we are only trying to maintain it and continue by not having Section 22 of this bill be eliminated. Further, let me say, I'm asking my colleagues to support this because it is in the right spirit. We spent most of this morning talking about in another amendment about the value of people not knowing how to purchase a home. And my colleagues, Mr. Chairman, on the other side, spent a lot of time talking about how individuals, many of those individuals would be veterans, how they didn't have the financial ability to take care of their financial business, so this would help. And I would like to yield the balance of my time to the sponsor of this amendment, my colleague, Congressman Heck.
Thank you so much. So first, just to reiterate, much of what this amendment would do is stand up or codify that effort already underway in the SEC. It's not due. It's not new. They're doing it. In fact, they've done it as a consequence of collaboration with the CFPB. And secondly, you know, what I cannot reconcile is, on the one hand, a philosophy that is kind of a pure form of idolatry of caveat emptor, with a resistance to then empowering the consumer in the marketplace to be able to better fend for themselves. You're already taking away so many enforcement authorities to pursue financial fraud here. Well, goodness sakes, then at least give the consumer the tools to be able to make the best decisions for themselves. And they are able to do that, frankly, with the funds that come from the Civil Penalty Fund. You would have those limited strictly to reparations for people who had been directly harmed by a specific case, as opposed to using some of those funds to help other people avoid ever being in that circumstance. So, you know, you cannot have it both ways. You cannot be caveat emptor in this pure, unadulterated, en rond form and not want to help the consumer be able to be self-sufficient and fend for themselves.
Time of the gentlelady has expired. For what purpose does the gentleman from Illinois seek recognition?
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. We can never tell our service women and men thank you enough. I'm so grateful for what they've done, what they continue to do, how they fight for us, literally. Freedom isn't free, and they show that every single day by their sacrifices. And so grateful for many of them who are coming back and wanting to make sure that they have every opportunity to have a growing economy here, good opportunities. And it's a big reason why we're doing the Choice Act, is to make sure that this economy can grow once again, that it can be that great opportunity for everyone, especially our servicemen and women. And so that's got to be our focus. And I'm grateful also for good
Programs always can be better, always things that we can continue to improve, but good programs to offer to veterans who are returning. One of the common themes I hear from, especially our younger veterans coming back from service, is they're just not sure where to go. There's so many different directions. They would love more one-stop shop type things where they can go to. Well, got good news, and that is that we've got that. It's working, and I can make sure that the sponsor of this amendment has a copy of this from the webpage from the SEC, investor.gov, focused specifically on our military. And just a couple of the SEC, through its Office of Investor Education Advocacy and its 11 regional offices, already out there, already in locations easy for people to access, has participated through the country in programs and initiatives aimed at helping members of the military invest wisely and avoid fraud. They're doing that. The SEC is a charter member of the U.S. Department of Defense's Financial Readiness Campaign and regularly assists in the presentation of financial education programs to the military. They're doing it. The SEC's Office of Investor Education and Advocacy has worked closely with the Financial Readiness Campaign partners on military outreach. SEC staff regularly participates in the Military Saves Week, as was mentioned by one of my colleagues, Financial Fair, held each year at the Pentagon. Resources, many great resources. SEC conducts its outreach to the military by conducting financial workshops on military installations, going right to where they're at before they even are out of the military, giving them that help, providing free educational brochures to support financial readiness events and activities, publishing content helpful to service members and their families on the investor education webpage of sec.gov and on investor.gov. So those are great resources right there, already in place, ready for our military and veterans to use. Interacting with military installations through the SEC regional offices located throughout the country. The SEC's Office of Investor Education and Advocacy and the SEC's regional offices are interested in additional opportunities to help educate members of the military and their families about investing and steps for avoiding fraud. Great additional information, an investor bulletin on a Roth, investor bulletin on saving and investing basics for military personnel, another connection of educational brochures that are available. Any questions or comments, direct email that they can have, or there's a hotline. There's already a hotline in place where specialists can call 1-800-732-0330. You can speak with an investor specialist from 9 a.m. to 5:30 Eastern Time. That's available to our veterans and military service members right now. They also have other websites here. Military One Source is a great source for them. Military Saves, another important source. So over and over again, Federal Trade Commission's military consumers, and also connection to the CFPB's website. So it's already there. There's already these things, and I do think the Office of Investor Advocacy is doing the work. They've got it all set up. They've got people ready to take your phone call. It's a little bit late right now. It's after 5:30, but tomorrow, if any veterans have questions, that number is available and accessible for them to call to get that help right now. We don't have to set up a new bureau or another bureaucracy for them to have to wade through. I also think it would just be a serious mistake for us to undercut repayment to victims, and that would be taking away 722, potentially harms victims. Payments to victims and class, we ought to make sure that they're compensated as quickly as possible. 60 days after the date of deposit, in a segregated account. Again, we need to make sure there's transparency, that this money isn't intermingled. This is victims' funds and it ought to be protected. And unfortunately, this amendment would harm victims of these type of activities, and money that should be going to the victims instead could be intermingled but for the work that's being done, the reforms that are being done in the Choice Act. So we need to protect victims. We need to make sure that payments are made quickly, that there's a 2-year window. That's plenty of time for payment to be made out to them. We shouldn't be holding it longer than that. And then there ought to be resolution. If they can't make that payment within 2 years, or if it's determined impossible or impractical to make those payments, then it ought to go to the Treasury. This all makes sense. I believe victims would be harmed. I also think, great news, our servicemen and women already have wonderful information that they can access starting at 9 a.m. tomorrow morning. I yield back.
Time of the gentleman has expired. Who seeks recognition? For what purpose does the gentleman from New Mexico seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The CFPB has been steadfastly criticized through the years that they've been active with regard to the Consumer Financial Civil Penalty Fund. The early
GAO study showed that they couldn't document that they had any controls over the disbursement. GAO could not document factors in distribution of $13.4 million in one claim they looked at. The process was additionally criticized in a $2.73 billion case where restitution of victims is rare, was the finding there. Only a small, in another commentary, only a small amount of the fund has been returned to investors. In another area, only a portion goes to the victims. The process is obscure is another criticism. In 2016, the CFPB was sitting on $300 million in relief fund, which then led to questions if they're actually charging the right amount, if they're coming up the right penalty amount, and they couldn't document how they came up with the penalty amounts. And then the reports about the distribution are routinely described as confusing. They don't allow outsiders to check how the money is being spent. And all of those then lead us to what Section 722 does. And if you just walk down through it, first of all, sets up segregated accounts. You'll recall the segregated accounts is what was supposed to protect the investors in MF Global, and instead John Corzine went in and took about $1.5 billion out of segregated funds. That's supposed to be against the law. The regulatory agencies never got around to really doing anything about him taking that money. I guess it didn't hit the threshold of concern. So we established the segregated accounts in Section 722, and then we established how the payments are to be made to the victims. We identify the class of the victims. We set a date, a number of days in which the agency is to be responsive, and then within 2 years, the payments of the victims which have been identified shall be made. So Section 722 is actually a very critical piece in dealing with the consistent complaints about CFPB and its handling of the civil penalty fund, and the fact that we're striking that out in this amendment is one that I just find very unusual and obviously can't support. So as we look at the process completely, if an agency is that obscure, I'm not sure exactly how they're going to give that great of an education to those veterans returning home. Having been in the category of a veteran returning home from a couple of years overseas, then I'm sympathetic to the process, but I also have recalled when I went to the government agencies in these sorts of things to get the education, did not find it to be overwhelmingly useful. And if we're using the billions of dollars that the CFPB has collected in fines and in penalties, then I suspect that we're overpaying for what we're getting. Would again oppose the amendment and yield back.
Jim yields back the balance of his time. Is there any further debate on the amendment? If not, the question now occurs on the amendment. I'm sorry, for what purpose does the gentleman from Nevada seek recognition?
Strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I want to begin by thanking my colleague from the Washington State for bringing this amendment forward. Mr. Chairman, there's no more patriotic act than putting on the uniform of the United States of America and standing in defense of our country. It is our solemn duty to look out for our service members the same way that they look out for us. Mr. Heck's amendment is common sense. We've seen the good work that the Office of Service Member Affairs at the CFPB has done, and I believe that we should see it replicated at the SEC. The new Office of Service Member Protection would provide service members with the tools they need to ensure that they're making educated financial decisions and not being taken advantage of. Financial literacy is something that we should all be supportive of in low-income communities, in communities with high numbers of immigrants like my district, and for members of our military. Service members are also provided an additional layer of protection from bad actors, like the protections provided in the Military Lending Act. We've seen the benefits that having a dedicated co-op on the beat has had. Why should we not have extended these successful programs further? My district contains Nellis and Creech Air Force bases, and a sizable number of service members call Nevada's 4th Congressional District home. We need to be working to protect those hardworking folks from unscrupulous actors, and I urge the support of my colleague from Washington's amendment and yield back the remainder of my time.
Gentleman yields back. Is there any further debate on the amendment?
I'd like to yield the remainder of my time to my colleague from Washington.
Okay, the gentleman from Washington is recognized for the remainder of the time.
Thank you, and I thank the gentleman from Nevada. Well, once again, let's just be very clear. This does not create a new bureaucracy in the SEC. In fact, what it does is simply codify everything you just spent 3 or 4 minutes over there saying you liked. I'm not quite sure why you wouldn't want to codify it if you're so much in love with it. That is its point, because we support it and we believe in it, and we think it should be codified because it is that big of a priority. And oh, by the way, in a similar vein, it's not clear to me at all why you think all of these kinds of efforts underway at the SEC, which we now seek to codify, but evidently you're opposed to, you do not support occurring at the Office of Service Members Affairs because, in fact, they are paid for by the Civil Penalty Fund, which you would take away from them. So you like that the SEC does it, but you don't like it enough to codify it, and you evidently don't like it at the Consumer Financial Protection Bureau because you're going to take all their oxygen away, and they're obviously going to expire. I simply do not understand how it is that you can claim to be as supportive of these efforts, which have had such documented success, notwithstanding the remarks just indicated, in assisting our service members. I yield back to the gentleman from Nevada.
Thank you, Mr. Chairman. I'd like to yield back the remainder of my time.
The gentleman yields back. He seeks recognition. The chair will recognize himself, and then I will be happy to yield to the gentleman from Ohio. Simply to say that if the program that the gentleman from Washington is alluding to at the CFPB is so robust, it begs the question why they've only had 2 distributions out of that civil penalty fund for the programs that he describes. Many of us believe that if you can't find a victim in a civil penalty fund after 2 years, maybe the people who have to pay for the CFPB, maybe they ought to get the money, that is, the poor, beleaguered taxpayer, which includes veterans who pay taxes and military personnel as well. Second point, according to the RAND Corporation, there are 56 different financial literacy programs spread across 20 different federal agencies. Sometimes maybe it's about making the existent programs more effective than necessarily creating even more programs on top of the ones that we have. And it's been pointed out by several members on my side of the aisle, including the vice chairman of the Capital Markets Committee. The SEC Office of Investor Education and Advocacy, which, by the way, predates Dodd-Frank, has already initiated a savings and investing basics for military personnel. So before we create a new program, maybe it would behoove us to have oversight over the program which is already existent and see if it is adequately meeting the needs of our service personnel. With that, I'd be happy to yield to the gentleman from Ohio.
Thank you, Mr. Chairman. And I think my colleague from Washington, Wright-Patterson Air Force Base is right near us. This past Saturday, I had the privilege of sending off the 371st Sustainment Brigade at Springfield Air National Guard Base, really at Wittenberg, but they train there. These folks are active in our community. I myself am a veteran. and I greatly appreciated the many benefits the people of the United States of America have bestowed upon veterans. And frankly, I'm glad, Mr. Chairman, that you addressed the desire to make the existing programs work better, because the status quo in Washington is when you find a problem, just to launch a new program, to launch an extra one. And you have program upon program. Frankly, it turns into a massive burden for the active duty personnel, for the reserves and National Guard, but also for the civil servants to administer and to oversee, when the common desire is to just help veterans in active force. So I look forward to working with my colleague from Washington to understand the pressing need that inspired this proposed amendment, but I also look forward to making sure that we move forward in this Choice Act. And so with that, I do oppose the amendment. I respect the intent and desire and look forward to cooperating to make sure that we do provide financial literacy, certainly not just for our veterans, for all Americans, but we provide the right sort of regulatory framework and protections to make sure that our markets work and do in fact create hope and opportunity for investors, consumers, and entrepreneurs. With that, I yield back my time, Mr. Chairman, to you.
I thank the gentleman for his comments, and I yield to the gentleman from Pennsylvania.
Thank you, Mr. Chairman. Like others have said, enough can't be said to thank our veterans and the work that they've done and to make sure that they have access to all the services that they deserve and have earned in defending our country. One of the concerns I've had about the CFPB slush fund is that Congress, frankly, has no authority over it. And to reform it and to make sure that the funds go to the victims is essential. But here's the beauty of bringing the CFPB into the regular appropriations process, where Congress gets to actually look at its budget and its line items, and to the extent that the director would have a program designed for veterans, specific to veterans, we can take a look at that budget number. Right now, we don't have any ability to look at the CFPB budget that way. So I would encourage our colleagues to take a look at the opportunity to bring the CFPB onto the appropriations process so that we can be making these decisions and making sure that the resources are being allocated. And I yield back.
The time of the chairman has expired. For what purpose does the gentleman from California seek recognition?
To strike a bunch of words.
Gentleman's recognized for 5 minutes.
Mr. Chairman, you may think that this place has gotten so partisan that I only listen to our side of the argument. I've been sitting back here, entertained by the oral commentary, but watching the screen. And nothing could catch my attention more than the statement you put up on the screen from the Business Roundtable, which stated, "We support several of the key provisions of the Choice Act." Mr. Chairman, I support several of the key provisions of the Choice Act. Break up this bill. Let us have a choice to vote for the provisions we support and the provisions we do not support. If you won't do it for me, do it for the Business Roundtable. We support, there it is up there. I want to thank the Republican side for letting me use their slide. We support several of the key provisions of the Financial Choice Act, undersigned, Business Roundtable, and Congressman Brad Sherman. Let's break up this bill. With that, I have almost 4 minutes remaining. Does anybody want me to yield? I'll yield back. Break up this bill was pretty, I'm not going to repeat it over and over again. I'm just going to yield back to the chair.
If you'll yield to me, I'll speak.
I'll yield to the gentlelady from New York.
I think he has a very good point. There's some Democratic bills actually in the bill that has wide support from Democrats, and if it was broken up, there would be support for them. But when you package it all together with what many of us think are poison pills, then there'll definitely be a negative vote on it. And actually, it would be great to work together on some positive directions forward for the economy in our country. I yield back to the gentleman.
I just want to add one more thing. And I made this comment earlier. The 12 bills here that have majority Democratic support, overwhelming Republican support. It could be said, well, okay, they'll be in the Choice Act. This bill isn't going anywhere in the Senate anyway. And then we'll take them up individually. And unfair as it may be, those good bills we pick up a virus by being in what has become a highly partisan bill. Now, folks that only know politics and don't know financial services will look at those bills and say, they were part of the Choice Act. And there will be pressure on members on this side of the aisle to oppose bills that they previously supported simply because of the very unfair guilt by association. So I'm hoping that at least the 12 bills that got majority Democratic support would be excised. That only takes, a quarter of an inch out of the bill. It still gives you a bill that's an inch high. So, you still have 400 or 500 pages at least. If you could just liberate the 12 imprisoned bills, not only would I appreciate it, but I'm sure the Business Roundtable would as well, and I yield to the ranking member.
Thank you very much. I just thought I would take this moment to talk a little bit about community banks, small banks, and credit unions. Our friends on the opposite side of the aisle keep talking about how terrible Dodd-Frank reform is for small banks and credit unions. I just thought I would go through some of the exemptions for small banks and credit unions in Dodd-Frank. Exempt from financial stability rules, exempt from CFPB supervision and enforcement, Consumer Bureau's close consultation on new rules, exempt from derivatives and other rules, deposit insurance improvements. Then the regulators themselves made some exemptions, regulatory flexibility to help community banks, credit unions. We've seen them take action to better tailor rules for small community financial institutions appropriately. And so we have been offering to the Republicans other kinds of ways that we believe we can help community banks and credit unions. They have not paid a lot of attention. Let me just mention some of them. Less frequent exams for rated community banks, eliminate annual privacy notice for community banks and credit unions, less stringent SEC registration for small thrifts, access to credit for privately insured credit unions, improved mortgage licensing for community banks. As it has been said, if you really cared, members on the opposite side of the aisle, about small banks, you would eliminate all of this stuff in this bill, wrong choice bill, and you would come up with a bill that would embrace that which
the time of the gentleman from California has expired. Who seeks recognition? The gentleman from Washington has already been recognized. Is there any other member?
Mr. Chair?
For what purpose does the gentleman from Florida seek recognition?
Strike word.
Gentleman is recognized for 5 minutes.
Thank you. I'd like to defer to the gentleman from Washington.
Thank you,
Yield.
sir. Mr. Chairman, it's not appropriate to be recognized a second time in order to ask unanimous consent to enter letters into the record.
Is the gentleman asking for unanimous consent?
Well, I'm asking a procedural question. I am, but I'm asking a procedural question.
Then if the gentleman would ask for unanimous consent, he will be granted unanimous consent.
Okay. Is it not appropriate to ask a second time? You're nodding your head. I don't know if that means yes or no.
Yes, it is appropriate if the gentleman would indicate that he's seeking unanimous consent. He will be granted it for the second time.
I ask unanimous consent.
Without objection. Who seeks recognition? Does the gentleman from Florida yield back?
I do, Mr. Chairman.
Is there any further debate on the amendment? If not, the question now occurs on the amendment offered by the gentleman from Washington, Mr. Heck. All those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. For what purpose does the gentleman from Washington seek recognition?
Ask for a recorded vote, please, Mr.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, for the proceedings on the amendment are postponed. Is there further amendment or discussion? For what purpose does the gentleman from California seek recognition?
I have an amendment at the desk.
We'll pause and allow the amendment to be distributed.
Okay. This amendment deals with...
The gentleman has not been recognized.
People here recognize me.
I thought that he did. The gentleman from California, didn't he say that?
What?
Oh, yeah, but he said hold off until they distribute. Oh,
Yeah, he did.
Okay. He did not say it nice.
Okay. You'll miss my scintillating comments.
Have all members received a copy of the amendment? Is there any member who has not received a copy of the amendment? In that case, the clerk will report the amendment.
Amendment offered by Mr. Sherman. Add at the end of Title V the following new subtitle. Subtitle S, Justice.
Without objection, the
for victims.
reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes on his amendment.
This is an amendment that should get support on both sides of the aisle. It deals with mandatory or forced arbitration, but even if you support arbitration, whenever the parties agree to it, even if it's snuck in a document that the consumer signs and you still support arbitration, you can't support arbitration the way Wells Fargo did it. Because it's one thing to say, okay, you open an account, you sign the paperwork, you sign the arbitration provision that's part of that paperwork, and you're bound by that arbitration with regard to the account you sign, that you opened up. But Wells Fargo said, you open up a checking account, you sign our document to open the checking account, and now if we fraudulently open a bunch of phony credit cards, arbitration applies there too. You didn't sign any of the credit card forms. And yet they say that you lose your day in court. That's simply outrageous. You didn't sign the arbitration provision with regard to the account that you didn't even know you had. Now, what happened at Wells Fargo? Over 1,534,000 false checking accounts. Over 365,443 false credit card accounts. These were not bookkeeping entries of little importance. Over 2 million serious felonies. 5,300 people fired. 2 million serious felonies, each involving a forgery, a wire fraud, bank fraud. Now, it's not just a $25 or $50 service charge that Wells Fargo was after. That's not the big money. The big money is on Wall Street, and that's why Stumpf testified here about how he was bragging to Wall Street investors, hey, we've now increased the portion of our checking account customers that have credit card accounts from 20% to 42%. And again on different dates at different times, he brags about his level of consumer penetration, drives up the value of his stock, not by $25 here or $50 there, but literally tens of billions of dollars. And the harm is not limited to the $25 or $50 fee here or there. We've heard from a particular consumer, they ran up a $1,300 fee, that was then sent to a collection agency, destroyed his credit, couldn't buy a house, he's still trying to untangle things. Now, arbitration isn't the solution, because if it's a $25 or $50 harm, how are you supposed to bring a separate lawsuit? I don't know any lawyers that will open a $25 file. And if it's a more sophisticated case involving the fact that you couldn't get a loan, your FICO score, I don't know any lawyer is going to take that for $500 or $1,000 or $5,000 even. What you need is a class action. And I wouldn't mind it if it was a class action arbitration. But what Wells Fargo does is it prohibits any redress at all unless you can find a lawyer who will handle your individual case. Now, you'll be told, oh, well, Wells Fargo settled these matters. Yes, they did. But they used the Jabari versus Wells Fargo victory that they had in court to settle for a lot less. The lawyers involved knew that they could have their whole case thrown out because of arbitration. The next fraud is just around the corner. It may be a little smaller in scope. It's hard to offer to commit 2 million felonies involving 5,300 bank tellers and other employees that needed to be fired. But it is simply, but if we do not act now, we invite this abuse in the future. There's huge money to be made for any banking executive that can brag to Wall Street about how they took a bank with 1 million customers that had 1 million accounts, and now they've got 1 million of customers with 3 million accounts, 4 million accounts. That's called successful marketing if it's legitimate, and it's called bank fraud if you do it the Wells Fargo way. So you can decide, is your dedication to binding arbitration so total that you believe it should apply in this kind of circumstance? Or you can vote yes for the amendment. I yield back.
Time of the gentleman from California has expired. For what purpose does the gentleman from Missouri seek recognition?
Strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I've always admired the gentleman from California as a very thoughtful individual, and I think he's maybe well-intentioned here, but my goodness, his amendment is fraught with problems. Number one, we have in here, in the first page, it says the Bureau of Consumer Financial Protection found that Wells Fargo management implemented sales incentives. Number two, it said that they found Wells Fargo employees engaged in improper sales practices. The CFPB didn't do anything. They sat on their thumbs. This is documented. Wells Fargo fired 1,000 people a year for 5 years. The third year, the local newspaper got wind of this and started to investigate, and lo and behold, they found some nefarious activities going on. I asked the question personally in committee of the Wells Fargo CEO. I said, because he said he didn't have a culture within his bank of this kind of activity. I said, you fired 1,000 people 5 years in a row? Maybe the first 2 years you cleaned them all out, but the third, fourth, and fifth years, you've got a culture problem. It starts from the top down.
Will the gentleman yield?
Be glad to yield.
I'll strike all the findings provisions if you'll vote for the amendment.
Reclaiming my time. Gentlemen, you've got to write a better amendment than this. This goes to the heart of what's going on here. You're giving the Consumer Financial Protection Bureau credit for something that didn't happen, and as a result, it really negates everything you're trying to do in your amendment here from the standpoint that the CFPB sat on their thumbs. And I asked the question to the CEO, I said, how many examiners were in the bank on a daily basis, year-round? He said between 75 and 80. And so the examiners, the OCC and Fed folks, they were able to turn around and go after the bank, which is fine. And I said in committee, they should have done that. They should have been fined. But the CFPB is like the little boy running after the train here saying, wait for me, and held her hand up, and oh, by the way, we're going to throw a fine at you too. And they were sitting there at the table and let it all go by. And so now here we are, they found this. No, I'm sorry, gentlemen, they did not do that. Second thing, within the Choice Act, we discuss, and the Choice Act eliminates CFPB's ability to write these arbitration rules. And basically, this is another, in my mind, another UDAP situation. Because this is another situation where they're getting ready to reinterpret and figure out how they can get into this space in some way because they believe that there's somebody that's been wrong somewhere, somehow. Now, I'm not saying that there wasn't anybody in the Wells Fargo case, that's true. But in the Wells Fargo case, let's be honest, it was found. Maybe not by the regulators, maybe by the news media, obviously by the bank themselves, but at the same time, the nefarious acts were found. So therefore, the people were punished. Why do we want to allow the CFPB to have this broad authority to continue to go after individuals and businesses and inhibit the ability of people to decide on their own whether they want to go to arbitration or not? I am flabbergasted. This is not a good thing. We have been working with the CFPB over and over and over on this stuff. We've railed it around here for the last 2 days. This UDAP authority, if they don't have something, they can use that to make up. And in fact, this is what they did, even in the Wells Fargo situation. They had 3 separate rules laws they could have gone after Wells Fargo on, and didn't even do that. They turned around and used their UDAP authority to go after Wells Fargo. Unconscionable. They continue to really just leave me speechless. It's breathtaking what they actually do and what they don't do. Mr. Chairman, I'm at a loss for words from all this. The gentleman, while he's a well-intentioned gentleman here, I certainly appreciate all his hard work. I certainly do not support his amendment, and I urge everybody to defeat it as well. With that, I yield back the balance of my time.
Gentleman yields back the balance of his time. For what purpose does the gentlelady from New York seek recognition?
To move to strike the last word.
Gentlelady is recognized for 5 minutes.
I yield to Mr. Sherman.
I want to respond to gentleman from Minnesota. First, he says, well, we shouldn't say the Consumer Financial Protection Agency found it. I'm perfectly willing to change it. It was the LA Times, my city attorney, Mike Fuhr, who found it and brought it to the attention of the Bureau of Consumer Financial Protection. Just as a judge makes findings, that's not because of his detective work, just as we have findings in this bill and in many bills, that doesn't reflect our detective work. It's find in the sense of determine, not find in the sense of be the original discoverer. But if you want to strike all the findings, all Section 592, which is support the amendment, I'll make the change. But the other argument, and an argument we've heard again and again here, is don't delegate a bunch of authority to the regulators. Don't just say we outlaw wrongful behavior and then have the regulators define what it is. This is a very specific bill. It goes on for pages. It defines exactly what arbitration provisions are not valid. And it does not require or even
It does certainly does. It is certainly applicable without the CFPB doing anything at all. It does not require regulations to clarify it or provide for its findings. I won't say that it's perfectly drafted, but it is a model of what every member on the other side of the aisle has been demanding, and that is that the law be written by legislators, that we determine what's acceptable, what isn't acceptable, and what the outcomes are. Here it all is. We define what the very limited types of situations in which mandatory arbitration cannot be imposed by the bank. Now, some folks say that arbitration is better for the consumer. That nothing in this bill prevents post-dispute agreements to arbitrate. So once you find out you have phony accounts, you can call the bank and say, let's arbitrate this. But if you don't want arbitration applicable to an account that you didn't open, it can't be imposed on you because of some document that you signed when you opened the account you did open. That's minimal fairness. That's what this bill calls for. And if the strongest argument you can come up with is to parse words about the findings, that ignores the purpose of this bill. The purpose of this bill is to protect consumers through its operative provisions, and those consumers deserve to be protected. And if you don't provide that protection, you are inviting the same thing happen again. If you do not learn from history, it will be repeated. So if you believe that it is in this committee and in this House that we should define what the law is and not leave it, to not give vague statements to be interpreted by regulators, you should love this bill. If you believe that people should have a right to a day in court that they shouldn't be deprived of when they are the victims of forgery and fraud, you should be for this amendment. And I will yield back to the gentlelady from New York.
Thank you. Mr. Chairman, I support this amendment. It will close a loophole and will clarify that forced arbitration clauses do not apply to checking and credit accounts, especially if they are fake accounts. And the most important part is that consumers deserve to have their day in court. I yield back.
Gentlelady yields back. For what purpose does the gentleman from Arkansas seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Appreciate the intent and thoughtfulness of the gentleman from California's amendment, and certainly I know many on the other side of the aisle have concerns about arbitration, and particularly arbitration where it's made part of a product or service contract up front with an eye that, perhaps the consumer wasn't aware of all the provisions or the responsibilities around arbitration. But I would say to the gentleman that since 1939, when the National Association of Security Dealers was formed and subsequently became FINRA in the 2000s, that arbitration has been used successfully and as a business model in the securities industry, not commercial banking that the gentleman referred to specifically in his example, but in the securities industry, both between investors and firms, so between clients and between broker-dealers, and also within broker-dealers to settle all matters of employee matters inside brokerage firms. And so I would urge my friend, if he's looking for a model of how arbitration can be done in the right way, with a lot of history, pros and cons, and best practices, I urge him to consider the success of arbitration over many, many years in the securities industry for both settling employee-related matters as well as between clients and member firms, broker.
Will the gentleman yield?
I would yield.
Arbitration may be successful in brokerage accounts, but do you know of any time when it's successful for phony brokerage accounts? Because my amendment here just deals with phony accounts. And I don't know of any circumstance since 1939 when arbitration has been a successful mechanism to deal with a circumstance where somebody opens one account and then, through forgery and fraud, the brokerage or financial institution opens half a dozen phony accounts. I don't think it's ever been helpful in that circumstance. I don't think the circumstance has arisen all that often. But you say that this has been a good system since 1939. It has not been a good system for dealing with phony accounts, and I yield back to you.
I thank the gentleman for yielding back, and I would suggest, though, it's an area, as you're thinking through this challenge and how to rectify it, that a model for how something could be structured that deals with the exact issue the gentleman has raised might be through studying this long track record of cases, arbitration cases, and arbitration dispute resolution methods to find a way to properly address this issue in the system. And with that, Mr. Chairman, I yield back to the chairman or to Chairman Lukemeyer, if you desire the time.
The gentleman from Missouri will take the time.
Thank you, gentlemen from Arkansas, my good friend, Mr. Hill. Yeah, I would like to just reiterate a few points here right quick. Basically what this amendment does is it eliminates the CFPB's, the Choice Act. The Choice Act eliminates the CFPB's ability to do arbitration, to write rules in arbitration. And it all stems from the fact that the CFPB has really gone beyond its authority too often. It's gone overboard. The pendulum of regulation has swung way too far. It's been too punitive in the actions it's taken. It's looking for ways to penalize people instead of help people. And by the actions that it's taken, it has stymied growth, financial growth, in a lot of different sections of our economy, and we want to stop them from doing that. Now, what you're trying to do, gentlemen, gives them that authority back. So we have a difference of opinion here. We don't want them to do it. We want them to keep...
If the gentleman will yield...
I don't have the time.
Time belongs to the gentleman from Arkansas.
If the gentleman from Arkansas will yield.
Yield to the chairman of the committee or Chairman Lukemeyer.
But anyway, just 13 seconds left. I'll just reiterate the point that, the reason for the Choice Act is we just don't trust the CFPB, their actions in the past. My dad always said you can judge the future by the past. And so if you know what's been going on in the past, this is not what we want to see in the future.
Time of the gentleman from Arkansas has expired. For what purpose does the gentleman from Michigan seek recognition?
Move to strike the last word.
The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I yield to Mr. Sherman.
I don't mind if you vote against the amendment out of partisanship. I don't mind if you vote against the amendment without reading it. But if you're going to attack the amendment for things that are obvious, if you would just read it, that's kind of where I draw the line. There is nothing in this amendment that gives any power to the CFPB. You say the CFPB shouldn't write the rules, the Congress should. This is Congress writing the rules and giving no power to the CFPB. You see the CFPB as a good agency. This does nothing to help them. You say the CFPB's authority in this area is obliterated by the underlying Choice Act. This amendment does nothing to restore any of that power. Why shouldn't Congress be fair to consumers? The answer is because some people don't like the CFPB. I know people who don't like the Red Sox, but that's not a reason for Congress not to do its job. And I know... So, I don't care if you like the CFPB or you don't like the CFPB. That's not a reason for us not to pass a statute fully complete in its statutory language, not needing interpretation or regulatory language, that simply says that if you create phony accounts, you can't hide behind arbitration provisions in the legitimate account. And if you think that those who engage in that level of fraud should be able to hide behind a document signed by the consumer when they operate, then fine, then stand up for that principle. But don't say it's because you don't like a particular sports team that will go unmentioned. Don't say it's because you don't like the CFPB. Say it's because you don't like consumers being able to have their day in court when they are the victims of 2 million phony accounts, each one of them involving several felonies. Each one of them wrecking, in some cases, a FICO score, crushing a family's ability to get a home or an automobile. Look at the substance. And if all you can argue about is that you want to vote against it because you don't like an agency that isn't mentioned in it, that isn't empowered by it, that is independent of anything it says, other than its findings, which I'm perfectly willing to strike if any Republican will offer their vote. If you're going to vote against the amendment, do it on the merits. I will yield back to the gentleman from Michigan.
Gentleman yields back. For what purpose does gentleman from Pennsylvania seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I think this amendment kind of highlights an issue with respect to amendments just getting dropped without us having had a chance to take a look and to think about this, because I think that the amendment raises some good points. It does. When I first heard about the case and the idea that it was going to go to arbitration, or that Walz was going to try to do arbitration, I thought that, well, clearly it wouldn't be within the scope of the arbitration because these accounts were fraudulently created. I think it raises a number of legal issues. We haven't had a chance to take a look at the decisions out of the district court and how the district court ruled and why they ruled, because I'm puzzled how the district court might rule in a context like this where they would compel arbitration. I do notice, however, and I think you mentioned this, the gentleman from California mentioned this, that there was a settlement. The settlement was for $110 million in the district court that the judge apparently approved. If I recall the facts of the case right, when the settlement happened with the CFPB and the OCC and the LA County District Attorney, total was $185 million. $100 million went to the CFPB, 50-some million to the OCC, 30 million to Los Angeles. I might be getting these numbers a little off, but only 5 million went to actual compensation for the victims. And to see that a class action was held, brought by attorneys, there were some stages of litigation. There was going to be a compelling of arbitration. Again, I'd like to find out more about that and how that happened, because I'd have serious questions about it. But be that as it may, for less than $5 million of actual damages, apparently there was a class action settlement for $110 million at the district court level. Apparently, outside of arbitration, the parties were negotiating whatever, and I think the gentleman suggested that perhaps the damage award would have been higher had that decision not been held to compel arbitration. But $110 million is a significant settlement for what was a $5 million compensatory number, apparently, from the settlement. But you look at the language of the amendment, you'd also want to look at the language in the arbitration agreement that somebody agreed to and how broad it was, how narrow it was. We don't have any of those facts here. So while I think that the amendment raises some very good issues, given everything else, and not really having had the opportunity to look at some of the legal issues involved, I don't think it's appropriate this time. I would yield back
Would you yield to the chairman?
I would yield to the chairman.
I thank the gentleman for yielding. I have listened carefully to my friend from California. He's offered to drop the findings if somebody on our side of the aisle would support his amendment. Probably a little doubtful that's going to happen. Perhaps he ought to drop the findings because I think they're demonstrably false. I think it's been proven by the record that CFPB found nothing on Wells Fargo until Wells Fargo reported. It was the LA Times. It was the LA City Attorney's Office. So the findings simply ought to be dropped because they're demonstrably false. Second point, with respect to the Bureau's own data, if one will analyze the Bureau's own data on arbitration, I think one would find that in class action litigation, the average recovery is $32.35, although the attorneys typically make out with millions. Yet in arbitration, the median recovery is $2,682. And I think somehow the gentleman from California implies that somehow there would be no justice to victims in Wells Fargo if due to arbitration clause. But as the gentleman from Pennsylvania pointed out, there's been $110 million apparently paid out to victims. And we know that there has been at least fines and penalties to Wells Fargo of $190 million. And before this whole sordid affair is over, there very well could be criminal penalties that are imposed as well. And so ultimately, I believe arbitration serves a very important purpose, and it ought to be protected, and we ought to reject the gentleman's amendment. I thank the gentleman from Pennsylvania for yielding time. The time of the gentleman from Pennsylvania has expired. Who seeks recognition? For what purpose does the gentleman from New York seek recognition?
Strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I yield to Mr. Sherman.
We're going to quibble. We want to deprive consumers of protection because you want to quibble about the word findings. The fact is, almost every bill that comes before this committee has findings, and in each one of those cases, the author of the bill didn't find the information. Findings means determination, not discovery. That's why this bill itself, I believe, has findings, almost none of which represent brilliant detective work done by a particular member. So if you want to say determined or concluded is the same as found, then we can pass legislation. Otherwise, much of the legislation that moves through this committee we could ignore the merits and vote against it because some people think that the word found can't be the word conclude. It must be the equivalent of the words uniquely discovered. Second, we're told that, okay, there was $110 million. That's about $50 per fraudulent account. Third, we're told that arbitration tends to get more money. That's right, because small matters can't be handled by arbitration. If you have 100 million people in this country who've been ripped off $100 piece and they have to go to arbitration, that means they each get zero. There is no case and it doesn't go into your calculation. The only time you can go to arbitration is when one plaintiff has many tens of thousands of dollars in claims. And that's why, of course, arbitration means, if it's successful, means that one plaintiff gets tens of thousands or at least many thousands of dollars. Class action lawsuits are the only vehicle allowed when the claims are rather modest per person. And imagine, since we're dealing with 2 million phony accounts, if they were major claims times 2 million, you'd bankrupt even Wells Fargo. So if we want to deprive consumers from any possible redress for claims that do not amount to many thousands of dollars per consumer, we can do that by defeating this amendment. Now, it is true that Wells Fargo thought that it might lose on this issue in a court. They had won all the court cases on this issue, including
Jabari versus Wells Fargo and several other cases. But they still might have lost eventually. That's why they settled for $110 million. But imagine how much higher that would have been if you had been able to have a subclass of people who applied for loans and had bad FICO scores. Imagine how much higher that would have been if the court had even looked at punitive damages. 2 million felonies, not 1 penny of punitive damages. 2 million felonies, not more than 2 million felonies, 2 million phony accounts, each one involving several felonies. So I think Wells Fargo's arbitration provision snuck into their agreement and then applied to the other phony accounts, saved them a small fortune. And in the future, when executives are trying to decide whether to push their employees hard enough so they figure some of them will create phony accounts, but what the hell will be, we won't push them quite as hard as Wells Fargo. The number of phony accounts as a percentage of total accounts won't be quite as high. They will remember what this committee does. And they will say, well, we won't push quite as hard as Wells Fargo, but we'll be able to brag to Wall Street that we have 3 accounts for every customer. Wells Fargo is trying for 4 accounts for every customer. We'll just push our people to give us 3 accounts for every customer. Maybe only one of those 3 on average will be a phony account. And if the consumer group, if the consumers object, we'll tell them, find a lawyer that will deal with your individual case. If you want to protect, if you want to see a repetition of this, fine. But again, if the strongest argument you can come up with against this bill is that the word findings must always mean uniquely discovered and cannot mean concluded, then explain that to consumers in your district.
Time of the gentleman from New York has expired. Who seeks recognition? Is there any further debate on the amendment? If not, the question occurs on the, for what purpose does the gentleman from Nevada seek recognition? The gentleman is recognized for 5 minutes. If the gentleman would hit his microphone, please.
Thank you, Mr. Chairman. Mr. Chairman, I have more than a few constituents who are customers of Wells Fargo, and I also happen to be a customer of Wells Fargo, and my colleague here to the left from Florida. There were an estimated 3,200 accounts in Nevada, just in Nevada, that were suspected of being fraudulently set up. Mr. Sherman's amendment is common sense. It's just saying that if an account is fraudulently established, forced arbitration clauses cannot be enforced. The American people should not be forced into arbitration with Wells Fargo for an account they never consented to in the first place. With that, Mr. Chairman, I'd like to yield the remainder of my time to Mr. Sherman.
I think I've made my case unless there are other easy arguments to defeat that are advanced against the amendment. I would simply say that it's going to be very hard to go back to consumers in your district and say, you open one account because you want one account. The bank opens 4 or 5 phony accounts, and you are bound with regard to the phony accounts for the account you intended to offer. You legitimately signed up for a checking account, and now you are bound and denied your day in court because you signed up for the checking account for the phony credit card account. If you want to defend that back in your districts, or just say on the basis of partisan solidarity, you decided to vote against something that would protect consumers, go right ahead. But don't try to argue about them about findings, because that certainly isn't going to work back in your districts. And with that, I'll yield back to the gentleman from Nevada.
Thank you, Mr. Chairman, and I'll yield back the remainder of my time.
Gentleman yields back. Is there further debate on the amendment? If not, the question occurs on the amendment offered by the gentleman from California, Mr. Sherman. All those in favor shall signify by saying aye.
Aye.
All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. For what purpose does the gentleman from California seek recognition?
I seek the yeas and nays.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. Sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? Who seeks recognition? For what purposes, gentlemen from New York seek recognition?
I have an amendment at the desk.
We'll pause and allow the amendment to be distributed.
You strict on that one.
Has every member received a copy of the amendment? Is there any member who has not received a copy of the amendment? The clerk will report.
Amendment offered by Mr. Meeks in Section 602A, strike paragraph 2 and redesignate subsequent paragraphs accordingly.
Gentleman is recognized on his amendment for 5 minutes.
Thank you, Mr. Chairman. Today I offer an amendment to strike a provision in the Wrong Choice Act. Section 602A would tie the hands of regulators, prohibiting them from limiting a bank's dividend payouts, even if that bank has demonstrated poor performance on their stress test. Mr. Chairman, this provision of the Wrong Choice Act unravels the reforms the American people demanded following the crises. During the crises, we saw banks continue to give payouts to shareholders despite experiencing a lot of losses. Lehman Brothers, for example, which eventually received taxpayer money, continued to pay dividends up until it imploded. Lehman had a strong incentive to continue its payouts to signal its strength despite being on a path toward failure. Mr. Chairman, when I offered the stress test amendment during the Dodd-Frank debate, we did so because we wanted to lift the hood of the car. Stress tests have given both investors and regulators an opportunity to better evaluate the health and strength of our banks. In fact, it has lifted the hoods of our financial institutions so that we can examine if the car is really in good condition. And anybody who has bought a used car or a car, you know that it could be a nice body, but if you don't lift that hood and look in there, then someone, the used car salesman, could really have you. So stress tests have allowed banks to better plan for the future. In fact, a 2016 PwC study found that banks that have used stress test findings in their day-to-day activities perform better than their peers. These banks had a higher earning strength, better capital, and higher quality assets because stress testing allowed them to intervene earlier and more effectively. An important tool used by our regulators is their ability to limit dividends when banks perform poorly on their stress tests. The Choice Act would strip this tool from our regulators. And how can a bank receive such a large gift in the Wrong Choice Act? They must simply meet a 10% leverage ratio, which fails to measure risks like stress testing does. The Choice Act's proposal is similar to telling our children, if you simply pass your gym test, there's no need for you to pass your history exam or for you to pass your biology exam or to pass your English exam. This simply does not make sense. All of our Dodd-Frank reforms work together to help regulators and investors determine the health of our institutions. They should not be traded off, and they should not be substituted for the Choice Act's weak leverage ratio. While a leverage ratio is good at determining if a bank has adequate capital to absorb large losses, as to avoid bailouts, stress tests are different and complementary. Stress tests allows us to determine whether, in spite of downturns, a bank can continue to function well and lend to borrowers. Following the crisis, we witnessed a credit freeze that rippled through communities. Businesses and creditworthy individuals could not access capital. If the Choice Act applied then, some banks would have passed its leverage ratio standard. In fact, according to the Clearinghouse, 1/3 of banks that failed during the 2008 crisis had leverage ratios that exceeded the 10% prior to the crisis. My amendment would strike this risky amendment. In fact, in a departing speech, former Fed Governor Tarullo noted that detaching stress tests from any limitations on dividends turns the test into a mere informational exercise. As a result, banks, investors, and maybe even regulators would take tests less seriously. All the virtues of stress tests, including its forward-looking approach to reducing risk, would be lost if the Choice Act provision is enacted. We cannot unravel our reforms like this. I urge support for this amendment. Let's protect our consumers.
Gentleman's time has expired. What purpose does the gentleman from Missouri seek recognition?
Strike last word.
Gentleman from Missouri is recognized for 5 minutes.
Thank you, Mr. Chairman. You know, one of the things that we're trying to do with the Choice Act is to take off some of the oppressive regulation and oversight, the punitive nature of that has been going on, especially with community banks. What you're trying to do, gentlemen, is take away the ability of the banks to manage themselves. You want to put the regulators in charge of the bank and let them micromanage it, which is what's going on. By striking what you've done here in the bill, you say that, because the bill, what it says is that it will exempt a bank from one of the federal laws with regards to paying dividends. If it's a well-capitalized bank, it's a one-rated bank, which means it's the best across the board, and it's got, say, 12% capital, and it wants to distribute some dividends to its stockholders, and it gets crosswise with the examiner, they can't do that because the examiner says, whoa, you can't do that. It throws a fit. We believe that the bank should be able to manage itself. If it's a one-rated bank, if its capital is 10%, it shows that it is being managed properly. When the regulators go in and they look at an institution, they look not just at a snapshot today, but they'll look back at the history of the management of the bank. I can tell you what they do is they look at, there's camel ratings, and there's 6 different categories, and they look at those things, and they go backwards as well as what is today, because they want to see the trend. If there's a trend where the bank is going in the wrong direction, even though the snapshot in time may be such that it looks like it's okay, they're going to note that. They're going to say, whoa, earnings may be good today, but they're less than what they were last year or the year before. The liquidity situation may be good today, but it's less than it was last year and the year before. The trend line is wrong, so therefore there's a problem. And they'll point that out. But if there's a 10% leverage ratio here, the thing that we're trying to do with this bill is give especially the community banks the opportunity to get out from underneath this oppressive regulation that is, with regards to the crash, 98% of the insured banks that had a 10% leverage ratio at that point, and very few of them ever went under. I mean, statistically, it shows that this works. Your point with regards to the stress tests, that's really for the big guys. And the big guys, I'm not sure they're wanting to get to 10% because that ties up too much capital. They really don't want to go there. They would rather leverage themselves a little bit higher rate. And that's fine. The stress test, or the leverage ratio is not for everybody. And it's arbitrary. If you want to do it, fine. If you don't, that's fine too. Doesn't mean you're a bad bank if you're less than 10%. But what it does say is that if you go to 10%, you're doing a pretty good job of managing your facility, your institution. You're doing a good job of meeting the needs of your customers, because you're not going to make any money if you're doing something wrong. So if you're doing something right, so you're managing your facility, why not allow those folks to do it in a way that continues to allow them to meet the needs of their community? The stress tests themselves, in my mind, are quite frankly a joke. Number one, the modeling that they use on the stress tests is arbitrary. They go anywhere from the mid-regional banks, anywhere from 20 to 30,000 pages. Your top, their largest banks, 100,000 pages, costs anywhere from 10 to 20 million to $100 million to put these things together. And yet the modeling on them is such that if you send it to the regulator, the Fed, and they don't agree with your modeling, they'll send it back and you'll ask them, what modeling do you want us to use? And they won't tell you what it is. You have to guess what kind of modeling they want to anticipate on your stress test to be able to pass it. How does that work? How in the world do you have to close your eyes, throw a dart at the board and hope that you hit something, and you spent all this time, all this money, and thousands of pages of documents to do a stress test? And quite frankly, as I've stated a couple times over the last 2 days here, with Wells Fargo, they admitted in testimony that they had 75 to 80 examiners in their bank. And this is not unusual. All the big banks have examiners there all day long, all year long. And so when you do a stress test, why? Why would you ask them to do that? The examiners are sitting there every day. They know exactly what's going on in the bank. And if they don't, which they did obviously in Wells Fargo, they should be fired. They should be the one that's fined. So to me, a stress test is quite frankly worthless. It's at a cost and encumbrance on the bank, because at the end of the day, the regulator should already be doing this job. Yield back.
Gentleman's time has expired. Any member who seeks recognition? Gentleman from Massachusetts. Gentleman from Massachusetts is recognized for 5 minutes. Gentleman from New York is recognized.
Well, it is clear. I mean, if there was stress testing, and we should have learned from the crises. Lehman Brothers had said it was still giving out dividends and apparently covering up, we didn't lift the hood, to see how they were going down. They were losing money, but yet for the appearance sake, they were still handing out dividends to their stockholders. And what we need to do is to make sure that when we're looking at what is really under the hood, for example, stress tests have proved successfully in restoring investor confidence after we've come out of the crises of 2009. And it makes sure that we have confidence in the financial health of the banks and increasing their capital at the banks where it is needed. Stress tests have evolved from a crisis management tool to a supervisory function so that we could help prevent another financial crisis by ensuring that banks preemptively build capital and to make sure that they are stable. So what we're saying is, and most experts, I would have asked unanimous consent to submit a paper from Brookings Institute where they looked at it and said that higher capital is not a substitute for a stress test. It is something that is complementary. We need to make sure in certain areas that capital is there, but and it works and the stress test works along with that, so that we don't want the taxpayers to feel again that they have to pay out or bail out any of our financial institutions also. Now, many members on this side of the aisle would agree with you in that, and that's why I think Mr. Sherman had advocated a long time ago that if we would pull out some of the community banks and some of the amendments there, we all want to make sure our community banks and small banks are protected and don't have to go through some of the regulatory rigors that the large banks do. I would love to do that, and there's some amendments and some pieces that we see that we could agree upon if we could get to that debate. But since we can't get there and this is all in one package, then we've got to try to make sure that we are able to continue with the protections that have been put in place so that we don't ever go back to 2009. My focus is the American taxpayers and the American people. We don't ever want to get there before, because if we do, then it is shame on us. That's what our jobs are. That's the reason why we had Dodd-Frank in the first place, is because of a financial crisis where there was things that were gone unchecked. If everything worked well, then we wouldn't be here. And we should not want to go back to where we were. That doesn't make sense, because then we're leaving ourselves open to the same kind of crises that we were at before. So it just seems to me reasonable that we have stress tests. And if you are doing bad in that stress test, then you shouldn't be able to give dividends. How do you give money? Will the gentleman yield? I'll yield to the gentlelady.
I just want to add my voice in support. I want to add my voice in support of the gentleman's amendment. And maybe I should take my own time. You can, because I don't have much time left. Go ahead. Or, okay. I just wanted to point out that the Choice Act provision that my good friend from New York, Mr. Meek's amendment, strikes would also undermine the FDIC's prompt corrective action authority, which is critical to safety and soundness, because it helps prevent bank failures in the first place. Prompt corrective action also allows the FDIC to limit capital distributions, which the gentleman's been talking about, and this bill would take that authority away. But why would we allow banks that are critically undercapitalized to give back money that they desperately need to shareholders? This is dangerous, and I hope that the majority reconsiders. The gentleman has a thoughtful and necessary proposal, and I support it. We should all support it. I yield back.
And let me just say also that, I'm looking at ways, again, that we can want to bring some of the costs down. I'm willing to work with you to look at ways that we can bring the costs down. The same thing that we talk about with Dodd-Frank and the Affordable Care Act. If we work together, we can figure out that for the benefit of everybody.
Time has expired. Gentleman from Massachusetts, time has expired. For what purpose does the gentleman from Arkansas seek recognition?
Strike the last word.
Gentleman from Arkansas is recognized for 5 minutes.
Thank you, Chairman. Appreciate Mr. Meek's interesting proposal here, but I really think that his concern is addressed adequately in Section 6 of the bill. I appreciate Chairman Luckemeyer's analysis of the stress testing issue, and I agree with that. As a former banker, these stress tests are highly hypothetical as they've been rolled out through the Fed's leadership. They are arbitrary. They're not transparent in the expectations or in the results. They are obviously cumbersome and expensive, but the most important thing is they are just a test, and they are very subjective in their assumptions. And so the real test for a bank is it well capitalized and is it got earnings? And if it's well capitalized and have earnings, it should have the right to distribute capital to its shareholders. And the whole premise here is this institution is well capitalized. It has 10% Tier 1 leverage ratio, a very conservative capital ratio, double basically the definition of well capitalized under the FDIC. And therefore, as long as it maintains that, it should have the right to distribute an appropriate level of earnings to its shareholders. Now, to Ms. Maloney's comment about prompt corrective action, of course that's important. And of course that's contemplated in Section 6. It does not get rid of the ability of regulators to use prompt corrective action. In fact, to the contrary, the Tier 1 leverage ratio, which is measured monthly by banks, reported to their board of directors, also reported to their state regulator if they have one, is reported to the federal government quarterly. And this Tier 1 leverage ratio reported quarterly, and if any time that ratio dips below 10%, the appropriate federal banking regulators shall notify the qualifying banking organization and any applicable state supervisor of that determination. The appropriate federal banking regulator may do what?
prohibit the banking organization from making a capital distribution. The banking organization shall, within 3 months of the first determination, submit a capital restoration plan to the appropriate banking agency. So that is the prompt corrective action methodology under Title VI of the Choice Act. It does not excuse undercapitalized institutions in any way. It causes them to properly capitalize themselves. But if they have that exceptional capital ratio of 10%, top of the food chain type performance for a typical commercial banking entity, they should be allowed to distribute.
Would the gentleman yield?
I'll yield.
I just want to remind the gentleman that 1/3 of banks that failed during the 2008 crisis had leverage ratios that exceeded the 10% prior to the crisis. I yield back to the gentleman.
Well, I'll be happy to check the numbers on that. I think that's, I'm not sure about that number. I won't stipulate that that number is accurate. Happy to review it. And as I said earlier in our debate, I believe yesterday, when this was being contemplated, personally, I liked a little higher number, even a more aspirational number. But the legislative process is one that is consultative and collaborative, and so 10% was selected. And I would say it was also selected by Tom Honig, the vice chairman of the FDIC, an appointee of President Obama to the board of the FDIC, saying that 10% was a solid aspirational capital ratio to use for this kind of regulatory relief that he postulated and argued before us back in April of 2015. So I do think 10% is adequate in this regard, and again, measured quarterly, and any deviation from it produces a prompt corrective action. I would yield any remaining time I have left, Mr. Chairman, to Mr. Lukemeyer if he wants to add to this.
Yes, thank you, gentlemen. Just a couple quick points here with the time I've got left. I'm not 100% sure of this, but I'm pretty sure there's only 2 banks that actually were over the 10% that failed. Everybody else was under it. And with that, you know, I've got so much other stuff to talk about here with regards to this. I'm going to need more time than that, so I'll yield back.
Yield back, Mr.
Gentleman
Chairman.
yields back. Gentleman from Arkansas yields back. Who seeks recognition? Does any member seek recognition? Gentleman from Georgia, for what purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. I would like to yield the balance of my time to Mr. Lukemeyer.
Gentleman from Missouri is recognized.
Thank you, gentlemen. You know, we've got a lot of things going on here. You know, basically the amendment says that if it tries to take away the ability of the bank to be able to manage its own funds with regards to if it's over the 10%. And we've got a few other things that are convoluted in here, but let's remember that if the bank is less than that, they still need to have approval. The FDIC can still restrict those dividends. And if they still need to be over 10% in order to be able to do that. So there's not everybody going to be able to do this, and it's going to be well-capitalized bank, well-run banks that are able to do this. With regards to the stress testing, you know, I've spent a lot of time talking to lots of the range of banks, all the way from the very largest down to the very smallest. And you've got, to me, I divide it in 3 different groups. You've got the largest banks, you've got the mid-sized regional banks, and you've got the community banks under that. The big guys actually don't mind a stress test. But I think the reason for that, quite frankly, is that they believe that by doing that, they appease everybody. And you make the point that it's good PR. The consumer believes that these stress tests show that there's a well-structured bank and it's a well-run bank. And this is one way to buy their goodwill after the debacle of 08. It buys the goodwill back of the consumer to have these stress tests be out there. The mid-sized regional banks, which were not part of the problem, just like the community banks were not part of the problem, they're stuck in the middle here with the stress tests. and you talk about working with somebody, this is where we could work together, gentlemen, because they don't need this part of it. They're not part of the systemically important group of banks. They don't need the stress test. They don't need the living wills. Yes, it's nice to have those things, but they're very expensive. I said a while ago, we had a committee hearing here, and we had to stack down there 20,000 pages of what that stack looks like of the documents that they have to submit to the FDI, to the Fed. It costs money, it costs time, and nobody reads it. They get a 3 or 4 page letter back from the Fed, and they say, well, you know, your modeling didn't work. And when you start looking also at the leverage ratio, there's a big difference in the way you figure the ratios based on risk weighting, which means you look at all the risks of the capital assets that are in that category versus your regular Tier 1 category. And for some of the large banks, when they do the risk weighting, yeah, they get over 10%, up to 12, 13%. But that's the problem, is it's a very subjective look at the weight of that investment. And let me give you a reason why it's a problem. One of the reasons the banks lost their shirts and were investing in these securitized bonds was that the regulators gave these securitized bonds a 0 risk rating for the banks, encouraging them to get into this area, to invest in these securitized bonds, knowing that there was a problem with them, knowing that the default rate was going up and up and up, knowing that there was a problem with some of the way these loans are put together. Yet they enticed the banks into investing in these things. And then they gave them a 0 risk weighting, so this risk weighting that the bank had in their modeling was worthless. And so when you look at some statistics on some of the bigger banks on how this risk weighting works, it's a joke. We had Sheila Bair in here one day. It's been several years ago, but she made the comment that the modeling doesn't work. The modeling is a joke because it's so arbitrary. To me, we've got a really big problem with the way that capital is determined, and what this bill does, the Choice Act, makes it very simple. It's very simple. The banking business is not that complicated when you break it down to the simplicity of assets, liability, and capital structure. And you look at the capital structure, and if you're in 10%, you're managing your bank, you know what you're doing, you should not have the government, the big brother hand on your neck, on your shoulder, telling you how to do things, restricting your ability to reward your stockholders for the investment, reward your customers for their trust in you. And to me, this is, your amendment takes that ability away of those folks to be able to best manage their bank for their own stockholders' best interests. And I yield back the balance of my time to the gentleman from Georgia. Thank you.
Gentleman from Georgia's time has expired. So any other members seek recognition? Is there any further debate on the amendment? The question now occurs on the amendment offered by the gentleman from New York, Mr. Meeks.
Mr. Chairman, ask for roll call.
I'm sorry.
Does Mrs. Moore seek recognition?
Vote
first. Vote first. Not yet. Vote first.
Does the gentlewoman from Wisconsin seek recognition on the?
Sorry about that. I'd like to move to strike the last word.
Gentlewoman from Wisconsin is recognized for 5 minutes.
Thank you. Let me start out by thanking my colleague, Representative Maloney, for offering this very important amendment. I yield back.
Gentlewoman from Wisconsin yields back. The question now occurs on the amendment offered by the gentleman from New York, Mr. Meeks. All those in favor?
Mr. Chairman,
gentleman from.
On that, I ask for the yeas and nays.
Just a moment.
I don't want to hear that.
All those in favor shall signify by saying aye.
Aye.
All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays have it.
Mr. Chairman, on that, I'd ask for the yeas and nays. I didn't need to hear that.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. Sufficient number having raised their hands, a recorded vote is so ordered pursuant to subsection C5 of Rule 3 of committee rules. Further proceedings on the amendment are postponed. Is there any other further amendment or discussion? What purpose does the gentleman from Florida seek recognition?
Thank you. I have an amendment at the desk.
We will pause while the amendment is distributed.
Thank you, Mr. Chairman. Thank you.
Have all members received a copy of the amendment? So the clerk will report.
Amendment offered by Christ. Page 378, after line 5, insert the following. Exception. The requirements of paragraph 5 shall not apply to...
Without objection, the reading of the amendment is dispensed with, and the gentleman from Florida is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman, for your graciousness. I want to take a moment to thank Ranking Member Waters as well. When I joined the Democratic Party in 2012, my friends warned me that the Democrats were historically disorganized and couldn't agree on much of anything. Of course, that was fine with me. I've only ever wanted to do right by the people I've been elected to serve, not one party or the other, but the people. But under Ranking Member Waters' leadership, the Democrats in this committee are united, and I thank her for that. It's hard to believe, but it is in fact true. We're united against a bill, the one before us, that I believe will take us back to the days of the worst financial crisis and the Great Recession. I thank her for her leadership in uniting us, and I thank you, Mr. Chairman, for your courtesy in the way you've handled this hearing. My amendment is simple. It says that the Consumer Bureau shouldn't have to jump through hoops to enforce fair lending laws. Why fair lending? I grew up in South St. Petersburg, Florida, an area that I am humbled to represent here in the Congress. In South St. Petersburg, our minority-owned and women-owned small businesses are the bedrock of our community. If they can't succeed, if they can't expand, if there aren't opportunities for new entrepreneurs, our entire community suffers. Without minority-owned and women-owned small businesses, there would be no economic growth. My neighbors would lose their jobs. Families would move away. Our community would be broken. These things would be intolerable. But South St. Pete is choosing a different path. The 2020 plan is a partnership between the Pinellas County Urban League, the City of St. Petersburg, and over 100 grassroots community organizations. Together, we are going to reduce poverty by 30% in South St. Pete by 2020. The plan has raised over $2.2 million in grants, private investment, and donations in the last 2 years alone. That money goes right back into the community, improving economically distressed areas and providing career training and social services. This 2020 plan is working, but it's only the start. To sustain our progress, my hometown needs reliable, consistent, and fair access to quality capital. But what we don't need is entrepreneurs and small business owners being denied access to quality financial products simply due to the color of their skin or the nature of their gender. But I'm afraid the bill before us may do just that, making it harder to prosecute fair lending violations. Why should the Consumer Bureau, the cops on the beat, if you will, have to undergo costly and dilatory cost-benefit analysis before enforcing fair lending? The answer is they shouldn't. It doesn't really make sense, and it's wrong. Discrimination doesn't affect us all, Mr. Chairman, but discrimination should impact all of us. to allow others, including our distinguished colleagues in the Congressional Black Caucus and the Congressional Hispanic Caucus and the Congressional Asian Pacific American Caucus, to be treated differently and put at a financial disadvantage due to the color of their skin is wrong. It flies in the face of who we are as a people, of who we should be, and who we are as Americans. Every day I wear a yellow wristband, and all it says is, love the golden rule. It's a reminder to treat others the way we would want to be treated, always. When it comes to loans, I think it's safe to assume that we all want to be treated fairly. The golden rule, then, would instruct us to make sure that everyone is treated fairly as well. This includes the minority-owned and women-owned small businesses. This simple rule, taught to us as children, tells us to do unto others as we would have done unto ourselves. And it's not complicated. It is important, and it is about fundamental fairness. That is why I propose this amendment. I want us all to be treated fairly. We're all children of God. Thank you.
Does the gentleman yield back?
Yes, sir. I'm sorry, I do.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Missouri seek recognition?
Strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. We had an amendment similar to this yesterday where we're trying to do away with a cost-benefit analysis. You know, that the cost-benefit analysis is there to ensure that the CFPB is not harming the very customers they're supposed to be protecting. Cost-benefit analysis is a basic and fundamental good government principle. This principle should apply in all circumstances, including this one. What's wrong with the cost-benefit analysis on all this to make sure that we actually protect the customers we're supposed to protect? These enforcement actions, by their very nature, are fact-specific. Nobody in Congress can foretell if the facts and the circumstances may arise around an enforcement action. It would be bad public policy to forestall examination of all the facts in every case. And I think one point to remember here, the director doesn't have to follow the outcome of the analysis. He just has to consider it. So why are we against considering as much information as we can? We have the gentleman from Illinois who has for 2 days talked about nothing but data, to make sure we have all the data we can talk about, all the data we can make the decision on. And he's right. I don't discount that. But here we are trying to not use data to make a good decision to protect the consumer. I'm not sure where all of the gentleman from Florida's discussion went on all this. I think that, at the end of the day, we're trying to find a way to be able to keep the cost of regulation down. That's what this bill's all about. To be able to allow people to have access to credit, affordable financial services, fair financial services to all people of all races, all income levels, all sex, whatever. That's what we all want. And that's what we need to do, because right now, as we were talking about in a couple of amendments ago, the arbitrariness of the CFPB leaves us, it takes my breath away when I see what's going on. And I talk to the people who have been touched by this, how they have been wronged by this. And it's not even the financial institutions. They will force financial institutions to do certain things, and then the outcomes of those things that they do to the institutions hurt the very citizens, the consumers they're supposed to be protecting. And even when we talked about a while ago, the monies that they recover, they're not even going back to the people. So it's very frustrating to sit here and see that amendment after amendment, we continue to want to try and prop this agency up that started out yesterday with UDAP violations, which that's probably the way this discussion should have started, because this whole bill is about the abuses of the regulators over the last several years, of what they've done to the financial institutions, whether it's banks, credit unions, credit bureaus, mortgage bankers, asset managers, you name it, across the board. there has been this proliferation of rules and regulations and this punitive nature of coming down on the boot on their neck to try and force them to do things that are not good sound management practice, good sound business practice. And at the end of the day, who's the person that pays the bill? It's the consumer. Who's the person at the end of the day that has suffered most? It's the consumer. Yes, the bank may go out of business, or the credit union may go out of business, but guess who loses in the end? It's the consumer. Why? Because they no longer have those financial services and financial products. Yesterday we talked about innovation. We need to help the banks be able to innovate. The Fed's trying to do a charter now on fintech companies. Whether it's good or bad, I don't know. We're going to talk about it on our committee. But the bottom line is there's a lot of new opportunities out there to do things. But as long as the CFPB is in a punitive nature of the way they do business, those things aren't going to happen. And so as a result of that, this amendment continues down that path of trying to, again, forget about the reason for the bill that we're trying to accomplish, and that is to take the boot off the neck of the financial service industry so they can deliver the services that they need to their customers and the communities and help them be the best they can and to grow. With that, Mr. Chairman, I yield back the balance of my time.
Chairman yields back the balance of his time. Who seeks recognition? The gentleman from Florida has already been recognized. For what purpose does the gentleman from Massachusetts seek recognition? Gentleman is recognized for 5 minutes.
Thank you. Thank you. The amendment that I've offered is trying to get the boot off the neck of people. It's trying to allow justice and fairness to be delivered more rapidly. Look, I served as Attorney General of Florida, and we didn't have to go through an analysis of what was right and wrong. All we had to do is properly investigate, use our due diligence to make sure that any investigation or any allegation that we looked into was done in an appropriate fashion. We didn't have to do a cost analysis, which would add more expense to government, which I know you're against. So am I. I don't want to add more expense to government and therefore tax the taxpayers more. I'm trying to relieve that burden. I'm trying to let a good agency do the job it's been designed to do, and that is to bring about fundamental fairness to all people in this country to have appropriate access to capital and not to be discriminated against. That doesn't take a cost-benefit analysis to determine right from wrong. So, with all due respect, I'm trying to take the boot off the neck. So, if you can look at it in that way, I think you can see that this is not trying to grow government. It is not trying to make it more oppressive. It is trying to do the opposite and let freedom ring and let more people in our society benefit from a system that provides capital to those who have traditionally been discriminated against getting that capital. And so I would ask for your support. We're really actually in accord. I yield back.
Does the gentleman from Massachusetts yield back? The gentleman from Massachusetts yields back. For what purpose does the gentleman from Michigan seek recognition?
Move to strike the last word.
The gentleman's recognized for 5 minutes.
So this amendment will, in fact, get the boot off the necks of businesses because they're not going to show up. They're not going to choose to play with the UDAP threat out there. You know, I kind of feel like this is Groundhog Day. I mean, we talked about UDAP last night, and we talked about state attorney generals and dozens of federal laws and state regulatory bodies and prosecutors and HUD and justice and class action lawyers and whistleblowers. Does the gentleman from Florida really believe that there is not adequate recourse out there today for people that violate fair lending laws? We don't need to give the federal government some broad authority to charge into some business like the mafia and say, you are guilty of unfair, abusive, deceptive practices, and we're going to extort a fine from you because you are worried about reputational risk, so we know you'll pay whatever we tell you to pay. That's how it's played out under CFPB. And what's neglected through this whole conversation is the Choice Act has a remedy for all this. It doesn't take away the ability of the federal government in any way to go in and accuse a lender of violating fair lending laws. All it does is it goes through the proper course so that we can have some kind of concept and assurance that due process will be honored. And that's what this is about. If this goes into effect, then you're going to find lenders following the course of auto lenders. They're going to be afraid to play, afraid to take the risk, and that is not the proper role of government. And I yield back.
Would you yield to the chairman?
I yield to the chairman.
I thank the gentleman for yielding. And I'm sorry, if we can hit the clock back, about 3.5 minutes. So I appreciate the gentleman for yielding. Again, I'm a little bit surprised at the resistance of a simple consideration of cost-benefit analysis. And in fact, in the bill, it's something to be considered, not something to be bound by, but something to be considered. And why is this important? It's important because we have an agency that by and large, does rulemaking by enforcement. So there's no notice, there's no comment, there's no other ability for us to realize are consumers overall being harmed, because the best consumer protection is actually having an access to a fair, competitive, innovative, transparent market. And so wouldn't it be nice to know that in an enforcement action that possibly, quite possibly, that credit will become less available, more expensive for the very people that the gentleman from Florida seeks to protect? I would hope that the CFPB would at least want to have that information, even if they're not bound by that information. And so I believe what is fair is, again, having access to a checking account. Wouldn't we want to know if an enforcement action in one individual case is going to have ramifications over the entire market for, once again, minority-owned, women-owned small businesses, for example? Wouldn't we want to know that? For example, in the CFPB's QM rule, I think it's kind of fascinating that it took the Federal Reserve to tell us that when it's fully phased in, 1/3 of blacks and Hispanics who qualified for a mortgage in 2010 will now be denied a mortgage. Will now be denied a mortgage. And for those who believe in disparate impact analysis, you would say the CFPB is discriminating against blacks and Hispanics under disparate impact analysis. And so wouldn't we want to know this? Maybe the CFPB should have known this before they promulgated their qualified mortgage rule. Now again, under our bill, they wouldn't have even been bound by it. But wouldn't it be a good piece of information for all of us to know that regardless of what happens in a specific enforcement action, we know it has ramifications throughout the marketplace and again can harm the very people that I know the gentleman from Florida is attempting to help. And so all we're asking is for a little common sense analysis on protecting, again, the most fundamental right that a consumer has, and that is the right to shop in a competitive, innovative, transparent market. That is the best form of consumer protection that we have for our citizens. And so all we're saying is, let's at least consider the impact of an enforcement action on our access to checking accounts, our access to credit cards, our access to mortgages. I think it's simple. I think it's common sense. And so with all due respect to my colleague from Florida, I would simply urge members to reject his amendment. And I thank the gentleman from Michigan for yielding time. The time of the gentleman of Michigan has expired. Who seeks recognition? For what purpose does the gentlelady from Wisconsin seek recognition?
Move to strike the last word.
Gentlelady's recognized for 5 minutes.
I just want to thank the gentleman from Florida for offering this amendment. I am 66 years old, so I have had a lifetime of experience assessing and evaluating the cost of discriminatory lending practices. As a matter of fact, I was so moved to start a community development credit union from scratch because I lived in a neighborhood that had been redlined for financial services, insurance products, mortgages, and we had had enough and decided we needed our own financial institution. First home I bought my first home, went straight to the insurance agent that had insured the house the day before I bought it, and somehow they couldn't insure that very same house the next day. I had to get into state force-placed insurance. Just recently, I got a $3,000 check back, work of the CFPB. Here I made $179,000 a year, just like all of you. But when I went in to get a car and had the look that I had, suddenly I had to pay a much higher rate. And of course, I got a $3,000 check back because that was totally inappropriate. I appreciate what the gentleman has done because as far as I'm concerned, this cost-benefit analysis is a proxy for a delay tactic in terms of providing the services, providing the financial services, and continuing to steer people out of mortgages, insurance products that they would otherwise be eligible to receive. I hail from Milwaukee, Wisconsin. I represent Milwaukee, Wisconsin. It was the first city in the United States to do fair housing tests where they would have a black couple go to buy a house, offering the same financial information, and then have a white couple go and prove that there was discrimination. And so the history of this is well documented. There's a lot of literature on it. And so a cost-benefit analysis, in my estimation, again, is an effort to deny that discrimination exists, and also gives the would-be lender or provider of financial services the excuse that they need as they continue to be paralyzed, paralysis of analysis. And so, Mr. Chris, thank you for offering this amendment. And unless you want time, I will, yes, I will yield the balance of my time to Mr. Chris.
Is that all right, Mr. Chairman? Thank you. Well, first, thank you, Ms. Moore. I appreciate your kind words, and obviously I agree with them or I wouldn't have sponsored this amendment. And it's probably because of experiences I had in the position as Attorney General of Florida, and I want to share a brief story. When I first got elected to that office in 2002, shortly afterward, we changed the law in Florida so that the Florida Attorney General could bring a civil rights action without the permission of the U.S. Justice Department because we believe in states' rights. The first case I heard about involved a action at a hotel in Perry, Florida called the Southern Inn. The proprietor of the inn went to the pool when an African-American family was there on the weekend, noticed that there were some of the children of the family swimming in the pool, and quote unquote, his words said, "No coloreds in the pool." We got word of that, Mr. Chairman. We investigated it. We found out that they were factual. There were affidavits signed. We sued. We won. That proprietor can never do business again in the state of Florida. We didn't need a cost-benefit analysis in order to determine right from wrong and to protect people who needed protection. This is the same kind of thing we're talking about here. I've talked to people in my district. A barber who wanted to get a loan couldn't get one. And no cost-benefit analysis is going to slow down, or would slow down, rather, this agency as it would have slowed down myself as Attorney General. So please support it. It's the right thing to do. Thank you.
Time of the gentle lady has expired. For what purpose does the gentleman from Pennsylvania seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
It's very important that our law enforcement and regulators be very aggressive when it comes to rooting out discrimination against anybody. What the whole idea here, and people were talking about boots on the necks of individuals, businesses, or whatever. What if in the process of getting the boot off of someone, more boots come down on others? I think that's the question. It's a simple question. And that's the analysis that should be considered. Is a government action going to do far more harm than good? And I think that the agency should be considering, when it's taking an action, will pursuing a particular action end up hurting minority and women-owned businesses, hurting minorities and women? What if the action that the agency was going to take was going to help one person but hurt 20, 30, 40 or more? It gives the agency an opportunity to look at the action that they were going to take and to tailor the action so that it actually addresses the discriminatory issue without having boots come down on others. And it gives the agency an opportunity to take a second look. Obviously, if they're going to be seeing discrimination, they're going to go after it. Because as we talked about, I think in the debate last night, these are matters of simple justice. In addition to there being any kind of cost-benefit analysis, if people are being excluded from participation in financial services, there is a tremendous cost to society for that beyond dollars and cents. And I think it's important for everybody in government to be taking a look at any action that they take and the consequences of that action, and to make sure the action is going to be tailored to address the injustice without creating a greater injustice to others. And that's what I think that this section of the Choice Act is all about. And I would like to yield the balance of my time to the gentlelady from Missouri.
I thank the gentleman from Pennsylvania for yielding. And while I so appreciate the sentiment of the gentleman from Florida, I have to say, as a woman who has certainly worked in a family-owned small business for many, many years, I, as I said, appreciate the sentiment here. But I have to say that the purpose of a cost-benefit analysis is to ensure that the CFPB is not harming the very consumers it is supposed to be protecting. Cost-benefit analyses, it's a basic and fundamental good government principle. Bottom line, this principle should apply in all circumstances, including this one, whether we're talking about minority-owned and women-owned small businesses or any other business out there. Enforcement actions, by their very nature, are fact-specific. Nobody in Congress can foretell the facts and circumstances that may arise around every enforcement action at all. It would be bad policy, bad public policy, and precedent to forestall examination of all the facts in every case. And certainly, the director of the CFPB does not have to follow the outcome of the cost-benefit analysis, only consider it. And I think those considerations are important. I think those considerations are important for common sense, for good business practice, for good governance. So I would oppose the gentleman's amendment, and I yield back the remainder of my time, Mr. Chairman.
Does the gentleman from Pennsylvania yield back? Who seeks recognition? Is there any further debate on the amendment? If not, the question now occurs on the amendment offered by the gentleman from Florida, Mr. Christ. All those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it.
Mr. Chairman,
For what purposes, gentleman from Florida, seek recognition?
Ask for a recorded vote.
Recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? For what purpose does the gentlelady from New York seek recognition?
I move to strike I have an amendment at the desk.
We will pause and allow the amendment to be distributed. Is there any member who has not received the amendment? The clerk will report.
Amendment offered by Mrs. Maloney, strike subtitle A of Title I and redesignate the subsequent subtitles and conform the table of contents accordingly.
Gentlelady is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. My amendment, which I am very happy to offer with Ms. Moore, Mr. Ellison, Mr. Meeks, and Mr. Lynch, would restore Dodd-Frank's Orderly Liquidation Authority, or OLA, which is one of the most important authorities in Dodd-Frank. The chairman and I have had a substantive debate over this earlier, but I truly do believe that eliminating OLA would be a major mistake and putting the economy and financial system at risk. And I believe it's important to remember that the FDIC has long had the authority to resolve failing banks, to resolve commercial banks outside of the bankruptcy process, and they did so very effectively in the last crisis. And all Dodd-Frank did was give the FDIC the authority to do the same thing for large non-bank financial institutions. This was very important because many of the big non-bank financial institutions were on the verge of collapse in 2008, and the government, we had only two options. Number one, a chaotic, disorderly bankruptcy like Lehman Brothers, or a bailout like AIG. Neither was a good option. Dodd-Frank gave the regulators a third option, an orderly wind down that prevents a government bailout but does not harm the broader markets. The highly respected Sheila Bair believes this was one of the most important parts of Dodd-Frank, totally supported it, as did Republican-appointed Chairman Bernanke, as did Republican-appointed Secretary of the Treasury Hank Paulson. But now, somehow, the majority has convinced themselves that this long-standing FDIC authority is some type of evil new taxpayer bailout, which is not the case. Under OLA, the losses are borne by shareholders, managers, and creditors. They are not bailed out at the taxpayer expense. There is no provision for the government to put capital into a failing firm in this Dodd-Frank. In some minds, allowing the FDIC to take over a failing financial firm, fire the management, wipe out the firm's shareholders, impose losses on the firm's creditors, and completely liquidate the firm, that in some people's minds, this constitutes a bailout. I know that some in the majority will say that the Orderly Liquidation Authority is a bailout because it allows the FDIC to borrow from Treasury to provide temporary debtor-in-possession financing to a financial institution while it's being wound down by the FDIC. I have two responses to this. First, when we were writing Dodd-Frank, the Democrats on this committee actually argued that we shouldn't force the FDIC to borrow from Treasury to provide this critical financing during an orderly resolution. Instead, we wanted to create an upfront resolution fund paid for entirely by private sector through assessments on the largest banks to provide this temporary financing. This upfront private sector fund did not have the lost out and was not supported by the Republicans. And so this brings me to the second point. The money still has to come from somewhere. And without a private sector resolution fund, we only had one other option, the Treasury Department. So that's what we did. We gave the FDIC the authority to borrow from Treasury in order to provide the temporary financing that's necessary in some cases to wind down a large financial institution in an orderly manner. But we also added a number of critical protections that ensure that this is not a taxpayer bailout. For example, the majority ignores the fact that by law, the FDIC has to get paid for its temporary financing, either from the financial institution or through levies on fees and levies on the entire financial industry. One way or another, the FDIC will get paid back. That is the law. The loans are backed by first claims on the first firm's assets, and so there is no taxpayer money used. The only group that is guaranteed not to see losses is taxpayers under the Orderly Liquidation Authority.
Time of the gentlelady has expired. The chair yields himself for 5 minutes. Although I appreciate all amendments that are being offered tonight, I really appreciate this amendment. And I really appreciate this amendment offered by the gentlelady from New York, my friend, because I'm not sure there is an amendment that more contrasts the different approaches between one side of the aisle and the other side of the aisle. So I find it, again, fascinating as my friends on the other side of the aisle continue to say that somehow the Choice Act is benefiting Wall Street banks when the New York Times, the Wall Street Journal, and the Washington Post all say they oppose it. Well, why do they oppose it? Well, maybe one of the reasons they oppose it because we take away taxpayer bailouts. This is exactly what this is. Title II, Section 10 allows FDIC to borrow from the taxpayer, the Treasury. It's taxpayers' money, trillions of dollars. Trillions of dollars. Now, I know my friends on the other side of the aisle say, oh, don't worry about borrowing all this money from taxpayers. One day it will all be repaid. Well, these are the very same people who told us that the National Flood Insurance Program would never need a taxpayer bailout. Now it's $26 billion underwater, pun intended. The Pension Benefit Guarantee Corporation, I think that's roughly $50 to $60 billion underwater. The FHA had to have a bailout. And so we are becoming a backstop, bailed out, bankrupt society. And so we Republicans have a different plan. It's called bankruptcy instead of bailout. And so the Choice Act provides for a new subchapter of the Bankruptcy Code for large, complex financial institutions that doesn't use taxpayer money. And what I also found fascinating is, under the living will process of Dodd-Frank, for my friends on the other side of the aisle, says, well, it's not possible to resolve one of these banks without taxpayer funds. That's exactly what the living will process requires, is that the so-called SIFIs, or the too-big-to-fail firms, must come up with a resolution plan that doesn't use taxpayer money. That's the Dodd-Frank living will process, supposedly. So again, Nothing could contrast the two parties more. So if you believe in bailouts for large Wall Street banks, then you'll want to continue to support Dodd-Frank. For the American people who are tired of the bailouts, who are tired of the AIG-like bailouts. The gentlelady from New York herself said AIG is not a good option, but under the Orderly Liquidation Authority, the FDIC could exactly replicate the AIG bailout, letting foreign banks and foreign creditors get 100 cents on the dollar. It was an outrage to the hardworking American taxpayer. It was an outrage to the factory worker in Mesquite, Texas that I represent. It was an outrage to the farmers and ranchers in Henderson County that I represent in the 5th District of Texas. And so we must repeal the taxpayer bailout system. What we need is a system that replaces complexity with simplicity, replaces bailouts with bankruptcy, and ensures that we have market discipline. There is nothing that will self-perpetuate bailouts more. Bailouts beget bailouts. And so what this does under Dodd-Frank is, it's no wonder that the big banks have gotten even bigger. The big banks have gotten bigger under Dodd-Frank, and one of the reasons is because they know they can count on the Orderly Liquidation Authority. They can count on taxpayer bailouts. And so they know the taxpayer will come to the rescue. Community banks, credit unions, they don't have this same exalted SIFI status, and maybe that's why so many of them are withering on the vine. It is time to put a stop to Wall Street bailouts. It's an outrage to the American taxpayer. Bankruptcy, not bailout. I urge all members to reject the amendment of the gentlelady from New York, and I yield back the balance of my time. Who seeks recognition? For what purpose does the gentleman from Minnesota seek recognition?
To strike the last word.
Gentleman is recognized for 5 minutes.
I yield time to the gentlelady from New York.
Thank you. I thank the gentleman for yielding. First of all, and I have great respect for the chairman. Under your bill, you repeal the living wills for banks over 10% of leverage ratio. And this is not an AIG-type bailout. Under the Orderly Liquidation Authority, you liquidate the firm. AIG was bailed out. It's still around. Under Orderly Liquidation, you would liquidate the firm. Under OLA, the firm's losses are borne by shareholders, managers, and creditors. They're not bailed out. And there's no provision for the government to put capital into a failing firm, as was done with the TARP program during the crisis. As I noted in my opening statement, the possibility that the FDIC could borrow from the Treasury to lend to a troubled firm, I know bothers the chairman, but a temporary liquidity backstop is likely to be necessary to maintain critical operations as the firm is restructured. And the same sort of backstop would likely be as needed under a Title I resolution as well. Importantly, though, these loans are limited in size, are temporary funding, not permanent capital, and they are backed by first claims on the firm's assets, and if that's not enough, by an assessment on other large financial firms. The only group that is guaranteed not to see losses in an Orderly Liquidation Authority is taxpayers. So it would, and also this power or this resolution authority under OLA could only be used if decision makers, including the Secretary of the Treasury and the President and the U.S. Financial stability is at risk. That's the only time that they could come in and make this happen. Otherwise, Title I bankruptcy procedures would apply. And I also want to point out again that this idea was first put forward by Sheila Bair, who did such a good job managing commercial bank failures in the crisis, and was supported by Chairman Bernanke, a Republican appointee, and Secretary of the Treasury Hank Paulson. So this item is critically important, in my opinion, for the safety and soundness and the ability to manage in a time of crisis. We don't know what the next crisis is going to be, but I can assure you there will be another one, and we should learn from what happened in the past. I can remember the hearings and Sheila Bair saying this was one of the most important things. We had to put it in place for non-bank institutions as we had put it in place for commercial banks. And that whole commercial banking area was managed. Our problem came when we had two very bad choices, either to bail it out or let it fail. Under orderly liquidation authority, you would have to liquidate. It wouldn't be bailed out like AIG. AIG's still around. It was bailed out. It wouldn't be around if you'd had the orderly liquidation authority. And I believe in this amendment. I believe that it's important to the stability of our financial institutions for protections in the future. Some of the finest minds in finance have put this idea forward in Dodd-Frank so that we don't face the same terrible choices that we had in the last crisis. So I urge my colleagues on both sides of the aisle to look at the facts. The facts don't lie. The legislation says no taxpayer money should be used. There are all types of areas that this will be repaid, and it's important for the financial to be able to prevent another financial crisis and to contain one. So I yield back to the gentleman from the great state of Minnesota, who is a co-sponsor of this amendment.
Yes, I urge all members to support the amendment as well, and I yield back my time.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Missouri seek recognition?
Strike last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. It's interesting. One of the unique things about our country and what makes it great is that we have the opportunity to succeed, but also we have the opportunity to fail. And why do I say that? The opportunity to fail is what reins in risk. If you have no risk whatsoever to anything you do, there are no consequences to anything that you do, you're going to do all sorts of stuff, aren't you? You're going to take all kinds of risks. If there's no reason for you to fail or no way for you to fail, you are going to do things that are not in the best interest of yourself. And if you're a business, you're going to do things that are not in the best interest of that business. And that's why bankruptcy is important. It needs to be a guardrail on risk. I remember, I'm old enough to remember this, I've got a few gray hair, some of you have never probably heard of this thing before, but there's something called a resolution trust, which back in the 80s, whenever we had the S&L crisis, this is where all the unfortunate savings and loans went to go. And we didn't use government money to bail those out. We used the Resolution Trust Authority of the FDIC to go in and either sell those institutions, merge those institutions, break up those institutions, or liquidate those institutions. And that's what we're trying to do with the Choice Act today, is to give the ability to the FDIC to be able to liquidate these things with a new chapter with regards to bankruptcy. Let the courts also be involved with regards to this. It's amazing that we have this mindset today that the government can solve all our problems if we just let them be the backstop for it. Well, who's the government? That's all of us. As the chairman just said, we've got a lot of different agencies that are in debt as a result of the the taxpayers being their backstop and for bad behavior or structured agencies by the way they're doing things. And so, to me, this is, it's really disconcerting to see that there is wanting to go back to allowing the government to be the backstop. And at the end of the day, what we've done with the Order of Liquidation Authority is really put in place to codify too big to fail. This is why the big banks were jumping for joy at Dodd-Frank. This is why the big banks are not enamored with the Choice Act. This is the leveling of the playing field section of the bill that they don't want to do away with. Because this basically is the implicit guarantee of the federal government that says you will not go under, and therefore you have an advantage over all the other banks in the system. Your local community banks, if they go under, they get in trouble, you think they'll get bailed out? No. Not even the regional banks don't get bailed out. Why? Because they're not big enough to have that ripple effect of being systemically important. This is why FSOC is also dangerous from the standpoint they don't need to be in the business of pointing out winners and losers. They don't do the job of assessing risk either, in my mind. So this is a situation, in my mind, where with this Early Liquidation Authority, we are codifying too big to fail, and in this we also give these federal agencies access to, guess what? The taxpayers' pocketbooks one more time to help fund these actions that they take to try and salvage his businesses. There are lots of ways to do this. Early Liquidation Authority is not the way to do this. Mr. Chairman, I certainly appreciate all the hard work you've done. I know this is a key portion of the bill. This is a key portion of how we can level the playing field for the banking community among themselves. It puts risk back in the system where it needs to be, which is in the banks themselves, which are privately managed and owned. I thank you, and I yield back.
Time of the gentleman has expired. For what purpose does the gentleman from Michigan seek recognition?
To move the strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Briefly, before I yield to the gentlelady from New York, Ms. Maloney, I would just point out that I understand the gentleman's point from Missouri about risk of failure being an important element in providing some discipline. But the way I read the OLA is that the risk is that if you are the management, you will be fired. If you are a shareholder, your interest will be wiped out. If you are a creditor, you will have losses imposed upon you, and the firm itself could be liquidated. So I think there's inherent risk. The question is not whether risk results in failure, but how the failure is managed with the least impact on the rest of the economy. And with that, I would yield to the one of the authors of this amendment, Ms. Maloney from New York.
I thank the gentleman for yielding. And to my good friend, I will point out that under the Orderly Liquidation Authority, you liquidate the firm. You don't bail it out. And in short, under OLA, the firm's losses are borne by shareholders, managers, and creditors. They are not bailed out. I must say I particularly enjoyed the gentleman's comments during debate because he worked for a bank and has a deep understanding of a lot of these issues. And I would implore him to read the bill and look at it, because in no way does it say there's a bailout. I also worked for a bank, but women had a ceiling on it. I was told I could not go into management. I could only be a service assistant handing out loans up to $10,000. That's why I'm probably in Congress today, because I had a ceiling put on me. But I respect your understanding of the financial system, but there's no provision in my amendment for the government to put capital into a failing firm that was done in the TARP program. Now, when Lehman failed, and filed for bankruptcy in 2008. The New York Fed provided temporary financing to Lehman for 3 days after it filed for bankruptcy. $63 billion the first day, $48 billion the second, $49 billion the third. That's an average of $53 billion in financing per day. And that's how much financing a financial institution would need while it's being wound down. Now, the Democrats, when we were doing Dodd-Frank, tried to set up a private sector fund, which was turned down by the Republicans. So the only place that government has the capacity to provide this kind of financing, especially in an emergency and on short notice, is through the Treasury. But the protections are put there. You will liquidate the firm. The losses are borne by shareholders, managers, creditors. And if that's not enough, it goes after their assets. And if that's not enough, it then goes back to other financial large firms by an assessment. The only group that is guaranteed not to see losses in an orderly liquidation authority is the taxpayers. And it's worth stressing that a resolution under OLA could be used only if key decision makers, Secretary of the Treasury, President, came together and said that this was a risk to the security of the country and Title I bankruptcy procedures would apply. Now my good friends on the other side always say that we should go to bankruptcy. And I would say that this particular amendment may be controversial to some people, but what should not be controversial is that ordinary bankruptcy procedures were entirely inadequate for the situation of the 2008 crisis. The bankruptcy judge in the Lehman case, required by law to focus narrowly on adjudicating creditors' claims against the company, had neither the tools nor the mandate to try to mitigate the effects of the failure on the financial system or the economy. The Fed, FDIC, and Treasury used the powers available to them, often in an ad-hoc way, to try to preserve the broader stability of the financial system of our country. But these agencies likewise lacked a framework for dealing systemically with failing financial giants. That's what this orderly liquidation authority gives. And again, it was endorsed and supported by Sheila Bair, Hank Paulson, and Ben Bernanke.
Time of the gentleman has expired. For what purpose does the gentleman from Michigan seek recognition?
Move to strike the last word.
I think other gentleman from Michigan.
Senior gentleman.
I appreciate.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And I want liquidity in the marketplace. I mean, for crying out loud, I'm the chairman of the Capital Markets, Securities, and Investment Subcommittee. Our main focus is market liquidity. But I don't want market liquidity at the expense of the taxpayer. And this is exactly what's happening. So Dodd-Frank is not ended too big to fail. I will point out that if it walks like a duck and quacks like a duck, it's a duck. And research by the Richmond Federal Reserve Bank shows that 62% of total financial system liabilities, some $27 trillion, are either explicitly or implicitly federally guaranteed, a figure essentially unchanged since the passage of Dodd-Frank. The interesting thing on that is, like, how does that play out? Well, I want to let you know how this plays out. Recently, I had a trip to New York, which I need to do in this new capacity, and I had a meeting at a law firm. And my host said, well, yeah, I had some unusual reservations, folks that said they wanted to come in and talk to you. They want to talk to you about something called OLA. So, looking forward to it. So I had this bank lawyer, a lawyer who represents banks, I should say, explain to me about how this all works and how he is able to lower the risk profile of banks because he can cite OLA. And he further went on and said, you know what, that he had some specific examples of where he believes that there had been loans, significant loans that would have been called in, or significant deals that would have gone bust had it not been for him to be able to go and say, you know what, the bank isn't at much risk as you think it is, because they've got this orderly liquidation authority, this OLA, this window to go to, where, you know what, you're going to be taken care of. So what he literally explained to me was that they were able to take greater risk simply because of the existence of OLA. All right? And so he was relaying his work and his ability to cite this existence of it, and he kind of must have seen the look on my face when he said, we might not agree on this one, right? And I said, no, actually, we really don't. We really don't, because I don't think it's a good thing that you are up here as a Wall Street attorney trying to figure out a way how you can take more risk with taxpayer money. And he said, well, you know, I hope you guys aren't going to go be serious about this and follow through on it, because that is going to change how we do business up here. And I looked at him and I was kind of like, you know what? Good. About time. And again, as I said, I want liquidity in the marketplace, but not at the expense, either explicitly or implicitly, by putting the taxpayer on the hook. And frankly, I'm stunned, shocked, and amazed that my friends across the aisle talk about nothing about risky behavior on Wall Street. And how in the world can this not be Exhibit A of what they think is wrong with Wall Street? And when this side of the aisle is talking about taking care of Main Street and not Wall Street, this is exactly what we're talking about. Because as my friend, the chairman of the Financial Institutions Subcommittee points out, all the banks that we deal with back home, except obviously of friends in New York City, they're not going to qualify for this. They have no ability to tap into this. They're going to be ignored. Now, you tell me what's more risky for the taxpayer than making sure that large institutional banks are going to be able to go out there and change their risk profile because they've got the ability to go to this, and our local, regional, and community banks cannot do that. So again, I welcome your support of OLA, frankly, on the other side of the aisle, because I don't think there is another issue that is more stark of a contrast between what we are trying to do here in the Choice Act, what we are specifically trying to do here in Title I. I'm not sure if it was on purpose or not, Mr. Chairman, but having this be Title I, the leadoff batter for what we believe as a party, as a committee, I think this is exactly the right way and the right step forward to move forward on this. So knock yourselves out, folks, over on the other side of the aisle. If you want to go and defend, how in the world you can go and defend this with a straight face? I'm baffled by that. I welcome your ability to go do that, but you ought to be supporting this, and I reject the amendment.
Time of the gentleman has expired. Who seeks recognition? For what purpose does the gentlelady from Wisconsin seek recognition?
Move to strike the last one.
Gentlelady is recognized for 5 minutes.
Thank you so much, Mr. Chairman. You know, there are some things, some days you just won't forget. The day Kennedy was shot, Martin Luther King Jr. was shot, 9/11/2001, and the day Hank Paulson walked in here with a one-page bill and said, give us $700 billion or the economy is going to collapse. You know, my first response to that was so similar to those of my friends on the other side, and I just said, oh, heck no. No way am I going to bail these banks out. But the contagion from something like a Lehman Brothers really was going to cause not only a collapse of our economy, but it was a contagion that would cause a systemic global failure. And that is the reason that something like an orderly liquidation authority was necessary. As the gentlelady from New York has pointed out, bankruptcy was too slow. And so the Democrats in Dodd-Frank original bill tried to have the banks pay this fee up front, and the Republicans didn't want to do that. And so we came up with this OLA. To strip this out from your bill is to institutionalize too big to fail, because you will not be able to play chicken. If one of these systemically important institutions like AIG fails again, we will have to to do something. You can't just say, oh, let them fail, because it's not just a matter of one institution failing. It is the contagion that will spread throughout the entire country, and indeed throughout the world. I know that you guys are ideologically committed to not bailing out these banks, but when Hank Paulson walked in here and said that the economy, and I do believe the economy would have crashed and burned, we will be right back in that same place without something like the OLA. And does the gentlelady wish to have the remaining time?
Yes. Yes. Well, I have great respect for all of my colleagues, and you can have your ideology, but the facts are there. And under OLA, the firm's losses are borne by the shareholders, managers, and creditors. They're not bailed out. It liquidates, it goes under. And the orderly transition is trying to save the impact on the overall economy, giving the same tools that the FDIC could use in commercial banks, which they used very creatively to stabilize the economy and stabilize the financial institutions. But under the OLA, taxpayers are protected because the first people who go under, the whole firm is liquidated, and the first claims are the firm's assets and then assessments on other large financial institutions. So this is tools that the regulators have asked for to help them manage in the future. God forbid that we don't have another one, but to manage the pain of it and to manage the stability of the overall economy. And again, this resolution, this idea, was proposed by Republican-appointed financial leaders, including Sheila Bair, who wins a great respect from me and I think most people. So I guess we agree to disagree. I believe it's an incredibly important authority, that it should be preserved. It's important to the financial stability of our country, and God forbid that we have another crisis. And I urge my colleagues to support my amendment, which is put forward with Mr. Ellison, Meeks, Lynch, and Moore. And I would say that the OLA is an essential tool for ensuring that that financial stresses do not escalate into a major financial crisis. This is a tool that they have asked for to help them resolve failing non-banks, the same authority that is given to failing commercial banks outside of the bankruptcy process. So I urge a yes vote on this amendment, and I yield back.
The time of the gentlelady from Wisconsin has expired. For what purpose does another gentleman from Michigan, Mr. Trott, seek time?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I just want to take a few minutes to respond to some of the arguments that have been made. And before I do so, though, I just want to comment on the gentlewoman's comments from Wisconsin and make one correction. The Republicans are not ideologically committed to not bailing out banks to save our financial system. That's not what this is about. We're ideologically committed to try and avoid government bailouts and putting the taxpayers at risk again. Now, my friend from New York, I have great respect for, and for her knowledge and experience, and she's become a good friend in my short time here in Congress. But her argument is that we need OLA because it provides for an orderly wind down of a failed financial institution without disrupting our financial markets. Well, I have good news. The Financial Institution Bankruptcy Act, which is the solution included in the Choice Act, provides all of the same benefits. It will provide for the orderly wind down of a failed financial institution without disrupting our financial markets, and it has the added bonus of not putting our taxpayers at risk. Now, the gentlewoman from New York argues that the taxpayers are not at risk under OLA, and the reason for that is the orderly liquidation fund maintained by the FDIC will be more than adequate to provide for the liquidity necessary under OLA. As I mentioned a few days ago in one of our hearings, I have little confidence in the government's ability to manage insurance funds. The National Flood Insurance Program is $24 billion underwater. As the chairman pointed out, I'm reticent to correct our chairman, but the Pension Guarantee Benefit Corporation is actually $79 billion in the hole. And so I don't know that the OLF will have the money necessary to deal with a bailout. So then we go to borrow money from the Treasury. So now we're borrowing taxpayer dollars, and the argument as to why that's not a bailout is, well, it's we're going to have levies, which I assume means a security interest in the assets, which may or may not prove to be adequate. Or the argument was made, the other players in the financial industry will pay for that shortfall. So now we're going to have innocent financial institutions paying fees to cover the mistakes of their competitors, and the money that those failed financial institutions use to pay those fees are consumer dollars, so now indirectly the taxpayer is paying for the bailout. Now, the Financial Institutions Bankruptcy Act has all the same benefits as OLA, and it has some additional positive aspects. First, the bankruptcy process is tested and true, decades of precedent. My friend from Wisconsin, the gentlewoman, pointed out that in the previous crisis, the bankruptcy process was too slow, and I think that was a correct observation, and that's why in the Choice Act, our solution provides for the same 48-hour stay to provide for the same efficiency and expediency that's in the OLA, so the bankruptcy process being too slow is not an argument anymore. The bankruptcy process is predictable. The solution provides for an experienced judge who's used to handling complex matters to deal with the administration of the case. It's transparent, so people can go in and sit in open court and find out what's happening with respect to this failed financial institution, not so with the FDIC. It's a very important point made earlier. It lowers the expectations. There does need to be a risk of failure in our marketplace so people can assess what they're doing. And under OLA, that risk does not exist under the bankruptcy process. Creditors know that there's a chance that they will get zero in a liquidation. It really comes down to a question, and if you take the taxpayer variable out of the equation, and at that point, if there's no bailout and the gentlewoman from New York is correct, then it really becomes a question of whether you want bureaucrats administering the resolution of a failed financial institution or a judge. I choose the judge because when you say this is not a bailout, in my experience, we can point to a myriad number of bailouts that the federal government has been involved in over the years, and I have no confidence that if a failed financial institution were to threaten our economy, that the government wouldn't step in with taxpayer dollars once again and bail out that institution. In the bankruptcy process, the private sector will provide the liquidity, and the judge will administer the case in just as an efficient fashion as the bureaucrats, with the transparency and confidence and predictability such that creditors and shareholders will be forewarned of the risks they're taking, and they'll have no confidence that the federal government will provide the backstop that's always been there. Thank you, and I yield back.
Gentleman yields back, who seeks recognition. Is there any further debate on the amendment? If not, the question now occurs on the amendment offered by the gentlelady from New York, Ms. Maloney. All those in favor shall signify by saying aye. All those opposed shall signify by saying nay. Nay, in the opinion of the chair, the nays appear to have it. The nays have it. Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? For what purpose does the gentleman from New Jersey seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk.
We'll pause and allow the amendment to be distributed. There seems to be some problem in finding the gentleman's amendment. Could he withdraw it for the moment without prejudice, and we'll return to the gentleman when we find the amendment?
Of course, sir.
Okay. Does the gentleman from Minnesota seek recognition? No. The gentlelady from New York. For what purpose does the gentlelady from New York seek recognition?
I have an amendment at the desk.
We'll pause and allow the amendment to be distributed.
Number 5.
It's styled Maloney 5.
I don't know where I thought they were going to go.
We're supposed to have 4 or 5. I'm joking.
Thank you.
Has every member received a copy of the amendment? If so, the clerk will report.
Amendment offered by Mrs. Maloney, strike Section 844 and redesignate subsequent sections accordingly.
Gentlelady is recognized for 5 minutes on her amendment.
I thank the chairman. This amendment, which I am offering with Mr. Ellison, Mr. Capuano, and Mr. Perlmutter, would restore the existing thresholds for shareholders who are allowed to put proposals on a public company's ballot. Currently, a shareholder can submit a proposal as long as he or she has held either $2,000 or 1% of the company's stock for at least 1 year. The Choice Act would eliminate the $2,000 threshold and would also lengthen the holding period from 1 year to 3 years, which means that in order to submit a proposal, shareholders would need to own at least 1% of a company's stock for 3 years. This would completely devastate shareholders' ability to influence the management of the companies that they own. Remember, it is the shareholders who own these companies, not the management. And yet the Republicans want to make it even harder for shareholders to file proposals on important governance issues. This bill would make it virtually impossible for ordinary shareholders to submit proposals at the largest companies. For example, under the chairman's bill, for a shareholder to submit a proposal at Wells Fargo, he or she would have to own $2.7 billion worth of Wells Fargo stock. Now, is this really the right time to be making it more difficult for shareholders to make much-needed governance changes at Wells Fargo or other financial institutions? But it gets worse. To submit a proposal at Apple, one of the best-known and iconic companies in the world, a shareholder would have to own more than $7 billion worth of Apple stock. According to the Council on Institutional Investors, the only investors in the world who would be eligible to submit proposals at Apple would be BlackRock, Vanguard, State Street, Fidelity, Northern Trust, Bank of New York Mellon, Berkshire Hathaway, and T. Rowe Price, none of whom have ever presented a proposal at an annual meeting. Both the New York State Comptroller, Tom DiNapoli, and the New York City Comptroller, Scott Stringer, who manage billions of dollars of assets for pensioners in New York, have written letters strongly opposing this section of the Wrong Choice Act. And I'd like to submit, with unanimous consent, their letters for the record.
Without objection.
The majority is always talking about how we need to promote capital formation by making it easier for companies to raise money from investors. And that's fine. Capital formation is important. But in order to raise capital from investors and thus promote capital formation, you can't constantly strip shareholders of basic ownership rights. If you prevent shareholders from having any real say in how the company is operated, then you will certainly make management's life easier, but you will make capital formation even harder. Investors simply won't buy shares if they get no ownership rights in return. But that's what this bill did. It would completely undermine shareholders' rights and would deter them from investing in U.S. companies going forward. So really, if the majority's goal is to increase capital formation, I think this provision is actually counterproductive. And I hope they reconsider their decision to trample on the property rights of shareholders. So if the majority truly believes in property rights, they should vote for our amendment. So I urge my colleagues, Republican and Democrat, to vote for this amendment, and I yield back.
Gentlelady yields back. The chair yields himself 5 minutes. First, it is a false assertion to say that somehow shareholders all of a sudden have no voice in a company due to the provisions of the Choice Act. All shareholders get to vote for the board of directors. That is a democracy in our corporate structure. That's the first point I would make. The second point I would make is that what we have seen is a rise, frankly, of political activism by those who are not interested in shareholder financial value. In other words, it takes the materiality concept and stands it on its head. The vast majority of shareholders are trying to maximize financial value so that perhaps they can take their equity and one day be able to buy their first home. Maybe they will take their equity and be able to send their first child to college. Maybe they can take their equity and start their first business. But instead, we are having these shareholder proposals from people who are not interested in maximizing the financial value of the vast majority of shareholders, but instead they're exercising their political values. And the way to do that is to engage in investing based upon your values. If you don't want to invest in a tobacco company because you don't agree with tobacco, don't invest in a tobacco company. In our society, there are people who have strong opinions about the life issue. In our society, there are people who have strong opinions about the Second Amendment. And if companies that are somehow engaged in these issues offend you, don't invest in the company. But don't try to diminish or denigrate the financial value of others who do. And so, for example, we have seen shareholder proposals that are all geared towards trying to take away First Amendment rights of those who engage in spending. And what we have seen is, for example, such shareholder proposals at Amazon, 95% of the shareholders opposed. At CVS, 95% of the shareholders opposed. At McDonald's, 95% of the shareholders opposed. At Coca-Cola, 98% of the shareholders opposed. Again, it is perfectly rational, reasonable for people to, in many respects, invest with their feet. If they don't like the policies of a certain company, they don't have to invest in that company. They get to vote for the board of directors. But what we have seen is, again, these proposals have to be dealt with by management. It costs money. It diminishes the financial value. And again, this concept of materiality, maximizing the financial value of the reasonable shareholder, has been a concept of the SEC since time immemorial. And instead, what we have seen is the rise of those who, for a very temporary basis, with minuscule shares, will attempt to hijack the process and hurt others. Other people who are attempting to use this investment to fund their American dream. And it's simply not fair to them. And so what you can literally have is somebody, for example, at Apple, who holds 0.0000003% of Apple stock, or 20 shares, can take up the entire time of management to diminish value for all of the rest of Apple shareholders. How can this possibly be fair to the vast majority of shareholders who are trying to maximize the financial value? It isn't. And so under the Choice Act, we have something fairly reasonable, and that is, if you're going to put forward these proposals, have some real significant skin in the game. And what we say is 1%. 1% to put forward a shareholder proposal. Anybody, again, can vote for the board of directors, but this is a system that has been abused, that is hurting the vast majority of shareholders. It must be reformed. That's what we do in the Choice Act. I yield back the balance of my time. Who seeks recognition? If no member seeks recognition, the question, is there any? No, I understand. The question now occurs on the amendment. For what purpose does the gentleman from Arkansas seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I want to speak in opposition to the amendment. I think that when we talk about shareholder rights, you have to understand that so much of American shareholders now are owned by mutual funds and money managers. We talked a lot about that today when we were talking about the fiduciary rule, and many shareholders own their shares in our stocks through collective means, like a open-end mutual fund or a closed-end fund or an exchange-traded fund, which fortunately this week the House acted on, the Foster-Hill measure to provide more investment research with help from Mrs. Maloney on that. But when you take that into account, the 1% of the company's securities is not a significant measure on behalf of millions of shareholders, Mr. Chairman. Apple was brought up. Fidelity owns 5% of Apple, State Street 3.5%, T. Rowe Price 2.7%, the Growth Fund of America over 2%, BlackRock 2.9%, Vanguard, the famous low cost, which was lauded today, low cost index fund-oriented company. Vanguard owns 3.9%. And so these companies have a goal, which is to make money for the millions of Americans that they represent in 401k plans, IRA accounts, individual shareholdings. And so they have every interest to make sure Apple performs ably and well and produces a good long-term return. And they easily meet the 1% test, and one would not call them a gadfly. These are serious long-term institutional investors and collective investment managers. Secondly, the proposal in the Choice Act to move from a 1-year holding period to a 3-year holding period should be applauded by both sides of the aisle, as we are constantly talking about a short-term orientation by shareholders and managers in public companies. But here we call for a holding period of 3 years, truly an example of a longer-term time horizon. So I think these are appropriate ways to focus shareholder rights and have serious proposals, because my friend from New York also talked about capital formation, and that the proposal in the Choice Act would hurt capital formation. I think the contrary. One of the burdens to capital formation right now is the cost of being a public company, and that cost has gone up and up and up by virtue of the regulatory system and the cost of registration, disclosure, maintenance, reporting, brought about by the normal SEC rules, the Sarbanes-Oxley, intrusion in things like the Conflict Mineral Act. So these costs are going up, and it's a detriment to entrepreneurial companies. Obviously it is, because that's why Democrats and Republicans created emerging companies and promoted the Jobs Act, clearly because of the cost of this. So by reducing the cost of a proxy solicitation, reducing the cost of maintaining the corporate governance process for a company, you're lowering SEC costs. Therefore, you are making it easier to go public, which means you are enhancing capital formation. The last thing I would say is this trend we have in society of frivolously attaching all topics to the proxy drives up costs, hurts capital formation, but it's also just a waste of time. What we need to be focusing on is producing long-term returns for our union pension plans, our individual shareholders, our 401k plans, and not be off tilting at windmills with what has become a social thing to do, which is attack our capitalist system through the proxy, using environmental, social, and political issues to make a statement, when none of these are passing. A study by the Manhattan Institute shows they don't pass. They don't pass. A proposal for choice hotels to determine how much water goes through every shower head went on their proxy. It didn't pass. So let's get serious about corporate governance and capital formation and reject this amendment. I thank the chairman.
Time of the gentleman has expired. Who seeks recognition? If there's no further debate on the amendment, the question now occurs on the amendment offered by the gentlelady from New York, Ms. Maloney. All those in favor shall signify by saying aye. All those opposed shall signify by saying nay. Nay, in the opinion of the chair, the nays appear to have it. The nays have it. A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? For what purpose does the gentleman from New Jersey seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk. I hope.
We hope you have an amendment at the desk. We will pause for a moment and allow the amendment to be distributed. Have all members received a copy of the amendment? If so, the clerk will report.
Amendment offered by Mr. Gottheimer. Strike Title 9, title Repeal of the Volcker Rule and other provisions.
Without objection, the reading of the amendment is dispensed with, and the gentleman from New Jersey is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. I'm offering an amendment with Mr. Foster and Mr. Heck, and I thank them for their help on this important matter. I'd also like to thank the ranking member for her and her staff's incredibly hard work on this marathon of markup. Mr. Chairman, in the height of the crisis, we had banks and non-bank financial companies going under. A contagion effect was spreading from one institution to another, freezing up lending from Bear Stearns to Countrywide Financial. There's a lot to debate here, but there's probably not much debate that our credit markets were locking up to the point where it was beginning to have a prolonged, crippling effect on Main Street and affecting everything from paying basic payrolls to buying homes. I'm a strong supporter of business in the financial community, especially in and near my district. I'm also supportive of smart and streamlined guardrails for them to operate in to allow basic banking services and capital formation. It's not perfect, and no legislation ever is, but the Dodd-Frank Reform Act took important steps to shore up our financial system and instill much-needed consumer protections. I believe we should work together across the aisle to make the legislation better. We shouldn't be afraid to do that. That's our job. Unfortunately, rather than improve on the regulatory framework, this bill is simply trying to snap back to 2008 to a point many in the industry don't even want. My colleagues on this committee were able to get to a bipartisan agreement on some provisions in this bill in the past, but in totality, this legislation rolls much of the language back to more partisan positions that risk imperiling our financial system. Rather than roll us back, Americans want to see us work together on smart bipartisan bill to move forward. This is a partisan bill without Democratic involvement. I recommend we work together to find bipartisan ideas to move the ball forward in a prudent fashion that all Americans can support. One of the causes of the financial crisis was the interconnectedness and depletion of capital from speculative investments and trading at our FDIC-insured banks. The Volcker rule attempts to mitigate these issues, but like many major policies, Congress and regulators should be in the habit of continual refinement. Refinement helps achieve the goals of the rule, including reducing systemic risk and reducing taxpayer bailouts, while still ensuring market liquidity and capital formation. Rather than the Choice Act's full repeal of the Volcker rule, which I fear goes too far, I'd like to offer a sensible amendment to strike the Choice Volcker provision and replace it with a requirement that the pertinent regulators conduct a study on the rule to see where perfecting it is needed. Specifically, the amendment asks for a report on the effects of the rule on market liquidity, streamlining compliance requirements, and consolidating monitoring and enforcement efforts. It also looks at systemic risk, including financial stability, taxpayer protections, and the impact to the Deposit Insurance Fund. With FDIC-insured banks required to reduce trading, it's worthwhile to have the regulators examine further the cumulative effects of their reduced involvement in the markets, including looking at how trading changed in the bond markets. How have non-bank participants responded to the banks being pulled back? What is the best way to measure these markets, and what do these metrics show? And even if they show a change in liquidity in the market or different pricing, we have to look at the cost of the financial system and the Deposit Insurance Fund. But we must always be mindful of systemic risk and especially study its impact on financial stability and taxpayer protection. American taxpayers can't afford another banking crisis that buries them in debt and socializes the losses of the banks. And regulators have been already talking about a desire to continue perfecting the Volcker rule. Former Fed Governor Tarullo recently acknowledged this in his farewell address, the complexity of Volcker, including how perfecting it may improve both regulatory and bank resources for compliance. It's probably fair to think about it like this. Could we perfect and actually get more resources to other issues like anti-money laundering or fraudulent accounts? Tarullo stated in his remarks, quote, "Efforts to achieve consistency in treatment across agencies have been both time-consuming and at times unsuccessful." He specifically pointed to the involvement of 5 different agencies, both an advantage to draw on their specific knowledge base, but a disadvantage that there's probably too many cooks in the kitchen. He also noted having to discern the intent of bankers on trades. Are we adequately capturing all prohibited trading or just some? Are we stifling the trading Paul Volcker intended to allow or allowing too much? In totality, we have to ask if the rule is perfectly achieving our goals, and can we make it better? That question is worth studying further, especially before a seismic action like full repeal. This study would help us make an informed decision on how we can continue to perfect our financial framework, ensuring stability, basic banking services, and efficient capital formation. I urge you to vote for my amendment, and I yield back.
Gentleman yields back. For what purpose does the gentleman from Michigan, Mr. Huizinga, seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Well, thank you. I appreciate that. And while I appreciate the gentleman's effort here, I would like to point out he has this language in here: within the 90 days, banking regulators and the Securities and Exchange Commission shall jointly submit a report on the status and impact of the Volcker rule. Well, Mr. Chairman, I don't know how else to say it. We've already done this. The Federal Reserve staff, banking regulators, issued a report in just this past December of 2016, already concluding that the Volcker rule has had a negative impact on fixed income markets, especially in time of market distress. And the exact quote that they had here is researchers at the New York Fed discovered, quote, "Our results show that bond liquidity deterioration around rating downgrades has worsened following the implementation of Volcker. We find that the relative deterioration in liquidity around these stress events is as high during the post-Volcker period as during the financial crisis. Given how badly liquidity deteriorated during the financial crisis, this finding suggests that the Volcker rule may have serious consequences for corporate bond market functioning in stress times, close quote. Additionally, in the 114th Congress, as part of the appropriations passed in December of 2015, Congress directed the SEC's Division of Economic Risk Analysis to conduct a study of the Volcker rule's impact on the fixed income markets. This report is due to this committee this June. So less than 60 days from now, we will have a report coming from DERA, the Division of Economic Risk Analysis, which is what the gentleman is asking for in 90 days. I'd rather wait 60 days and get what the work that they're currently doing. And for the reasons the amendment is not necessary, and with, frankly, further delay and needed repeal of the burdensome rule that has already impacted our capital markets. I, as much as I would love to continue to talk because I'm a politician with a microphone, but geez, oh Pete, it's 10 o'clock and we've been at it for 12 hours. I'm happy to yield to the gentlelady from Missouri if she would care to chime in.
I thank my friend Mr. Huizinga for yielding. Not only, Mr. Chairman, is the Volcker rule completely irrelevant to the problem of financial stability, it is also affirmatively harmful. It weakens banks because it deprives them of a profitable business line stream that helps them diversify their revenue streams and better manage their risk. There are numerous banking experts who have said, and I'll quote Robert Litton and others who say, to the extent that proprietary trading has been profitable for banks, denying them the ability to pursue it could detract from their safety and soundness. In other words, the Volcker rule doesn't make the financial system safer or stronger. It makes it riskier and, frankly, more fragile. The Volcker rule also dries up much-needed liquidity in the financial markets. Researchers at the New York Fed discovered, and they, again, another quote, our results show, this is from the New York Fed, that bond liquidity deterioration around rating downgrades are worsened following the implementation of the Volcker rule. We find that the relative deterioration in liquidity around these stress events is as high during the post-Volcker period as during the financial crisis. Given how badly liquidity deteriorated during the financial crisis, this finding suggests that the Volcker rule may have serious consequences for corporate bond market functioning in stress times. It is, Mr. Chairman, long past time for Congress to carefully consider the trade-off between the benefits of that Volcker rule offers and the costs that it frankly imposes. The benefits are few and the costs are enormous. It is time for the Volcker rule to go. I thank the gentleman from Michigan for yielding.
My pleasure to yield to my friend. And again, I guess I would just like to say, I believe this is redundant. Appreciate the gentleman's efforts. We have a report coming that is going to be due here at the end of next month, no later than the end of next month. We've already had a report that was submitted December of this year past. And I look forward to passing this bill, the Choice Act. So with that, Mr. Chairman, I yield back.
Gentleman yields back the balance of his time. Who seeks recognition? For what purpose does the gentleman from Illinois seek recognition?
And strike the last word.
The gentleman is recognized for 5 minutes.
Well, I'd like to thank Representative Gottheimer for offering this common sense amendment today. The Volcker rule is a central component of Dodd-Frank's policy response to the financial crisis. Repealing it is not something that enjoys bipartisan support, and frankly, did I say that right? It's late. Repealing it is not something that enjoys bipartisan support, and frankly, it does not seem to enjoy a whole lot of uniform partisan support. Secretary Mnuchin indicated in his Senate confirmation hearings that he could not and would not support repealing the Volcker rule. Our chairman actually quoted in the Wall Street Journal on March of 2013 said, quote, certainly we have to do a better job ring fencing, firewalling, whatever metaphor you want to use, between an insured depository institution and a non-insured investment bank, which is a sentiment, I think that certainly all of us that actually lived through 2008 would agree with. And so I wish that we were here today considering bipartisan ways to improve the Volcker rule, and which is something, as was mentioned, that Governor Tarullo suggested last month, that there were ways to simplify the rule. The rule is of necessity quite complex, and that's because the system it is intended to put constraints on is itself very complex. This is an intrinsic feature of regulations for a complex financial system, and I think we have to take a mature attitude toward that. And it seems as though this ought to be an area of low-hanging fruit in finding bipartisan compromise. I believe this amendment should be adopted, and I think that the report that it would require, which would be very much focused at identifying specific changes to improve it rather than is this something we should repeal, will shed some useful light on the ways that we can improve the rule. It is absolutely crucial that banks not become overexposed to capital markets the way they were in the run-up to the crisis. However, banks often play an integral intermediate function. For example, they play integral intermediary functions, for instance, that efficient, well-functioning markets depend on. Market making and other means of providing liquidity need to be allowed in a responsible fashion. I'm interested in hearing more about specific changes to Volcker that retain its core objective of providing stability to the banking system and protecting the deposit insurance fund. I believe there are ways to streamline compliance requirements that will make compliance easier and oversight more efficient. These are areas that I look forward to working with on members of both parties and the regulators after we debate and dispense with the Choice Act, because the Choice Act's repeal is not, as has been mentioned, a provision that is likely to become law. The 10% leverage ratio in this bill, which is presented as something that will stabilize the banking systems against all foreseeable risk, is woefully inadequate to allow a bank to engage in unlimited activities that led to the overexposure of, for example, to paper that proved worthless. There probably is some amount of capital that a firm could hold where we would no longer have to worry about its activities and the risk to taxpayers that they create. But this bill is nowhere near such a level of capital, and indeed requiring an amount of capital where you could tolerate unlimited exposures in our banking system, would not be optimal for the overall broader economy. And that is why it continues to make sense to have reasonable restrictions on the activities based on those funding sources. So I urge my colleagues to support the Gottheimer Amendment today and work on compromise to perfect the Volcker rule after this markup and its partisan joys are finished with. And yield back the balance of my time.
Chairman yields back. Is there further debate on the amendment? If not, the question now occurs on the amendment offered by the gentleman from New Jersey, Mr. Gottheimer. All those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it, and the amendment is not agreed to. For what purpose does the gentleman from New Jersey seek recognition?
Can I call for a recorded vote, please?
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, further proceedings on the amendment are postponed. Is there further amendment or discussion? There being no further amendment in consultation with the ranking member, we will soon recess. We will reconvene tomorrow morning after first votes on the floor. That will be approximately 11 a.m., at which time we will vote on pending amendments and passage. This committee stands in recess.